Okay, my name is Bob Schiffmacher.
Recording
It is the
in
afternoon.
progress.
It's the afternoon session of the State Board of Equalization hearing on October 5th. We are starting with agenda item E. Kelly, if you would call that agenda item, and then I have some comments.
Yes, Thank you, Chairman. Item E for possible action, appeals from the action of a County Board of Equalization pursuant to NRS 361.400, tax year 2023-24 secured roll, 2022-23 unsecured roll, and 2022-23 supplemental roll. So
the cases that come before us now are 117 through 134, 136, I apologize. So it's 117, 118, 120, 135, 137, 138, and 139, and 136. Having read the files, it seems as though the issues are identical at this stage on all 8 of those cases. Is there an objection from either party to consolidate those cases for discussion?
Mary Ann Widener with the Clark County Assessor's Office. There's no objection on the county's part.
Jim Sousa, the Deacon Senior McDonald Law Firm. There's no objection on our part.
So in that case, I will move that we hear cases number 23, 117, 118, 120, 135, 137, 138, 139, and 136 in a consolidated basis. Do I have a second? All in favor?
Aye.
Aye.
Aye. Aye.
Any opposed? Hearing none, that motion carries. We'll hear the...
Mr. Chairman,
Yes, sir.
this is Tim Morse. I would like to point out that I previously have done quite a bit of work for Mr. Sousa and his law firm. I did appraise quite a few of these properties in my life as an independent fee appraiser. That was, I think the latest one was like 10 or 12 years ago. I am not actively appraising properties presently, and in the appraisals that I did do of these properties, I was complying with uniform standards of professional appraiser practice to identify and value the personal property separately, which was pretty much inconsequential compared to the going concern value that the properties ultimately that I arrived at. So I just wanted to bring that onto the record. I have worked for MGM and I have worked for Mr. Sousa, but they were quite some time ago, and I don't think it's going to affect my judgment in dealing with these matters at hand.
So in essence, although you've had prior relationships with these properties and these participants, you will not be recusing yourself from this case.
That's correct.
Okay, thank you. I think it is, even though the assessor is the appellant, the first step is to identify the properties in general terms, orient us to the properties, and then somebody correct me, Sam, maybe you could help me in terms of the order of how this case needs to be heard.
Yes, Mr. Chair, Sam Taylor for the record, the AG's office.
I'll do that. Go ahead, Sam.
Yeah, technically you would let the person filing the appeal go first, then you would have the person who, the respondent go, and then you would give the option back to the appellant.
So the agenda, or the outline includes one additional step, which is to briefly identify the property, and that would be the appellant.
Yes.
So they would move from that stage to the presentation, and then it would move to Mr. Souza,
That would be correct.
and then
yes.
back. Okay.
Yes.
Very good. Let me just do one housekeeping item. Given Mr. Morse's disclosure, do either party have an objection for him to stand in or sit on the dais?
Mary Ann Widener with the Clark County Assessor's Office. The county has no objection.
Jim Sousa representing MGM, they have no objection.
Super.
Chairman Schiffmacher,
Yeah.
this is Christina Griffith
Yes,
for
ma'am.
the record. I just wanted to let you know, the Clark County Assessor is the one who is the petitioner in this case, not Mr. Sousa. So I believe they would be the ones going first. And the assessor does have some new evidence, in case you didn't see that needed to be addressed as well.
Okay.
Mr. Chair, that is consistent with what I said.
Yes, I agree completely. So if you would orient us to the properties, Mary Ann, and explain why we should accept the new evidence and to what purpose it would be provided.
Absolutely. Mary Ann Widener with the Clark County Assessor's Office. The properties that are in association with the cases that you've already combined here are the Aria Resort, located at 3730 Las Vegas Boulevard, the Cosmopolitan Las Vegas at 3708 Las Vegas Boulevard, the Bellagio at 3600 Las Vegas Boulevard, the Park MGM Hotel and Casino at 3770 Las Vegas Boulevard, the Luxor Hotel and Casino at 3900 Las Vegas Boulevard, the Mirage at 3400 Las Vegas Boulevard, the MGM Grand at 3799 Las Vegas Boulevard, and the Mandalay Bay Hotel and Casino at 3950 Las Vegas Boulevard. And the subject of the petition is the personal property part of the value that's located at those locations that I read forward, and not the real property. It is strictly the personal property, and it is for the 22-23 fiscal year.
Thank you. There is new evidence that we received last night or this morning. Is there a reason why we did not have that as part of the original package?
The first part, well, with regards to what was sent last night, we do not believe that is new evidence. It is a summary and an extract of evidence that was already presented to the county. We just wanted to put it in a visual format and group it together instead of having the board have to go back and forth through various pages. The pages for each one of these cases is over 10,000 pages long. And so,
Well aware.
so we tried to make it more efficient. So all of the information that we're presenting was information that was in the original case. There's one calculation, I believe, or two calculations on one column that is just a calculation on the information that's there, just so you can visually see it. We've spoken to it, we will speak to it. That's what was submitted last night. And then in addition, what else was that? Was just, just those two things? Yep, those two things.
The side-by-side.
That's what I did. And yeah, and the other information, it has to do with the tables that we're going to be discussing that are both in the personal property manual and in the taxpayers' evidence that they had presented to the county board. We just wanted to try to put it side by side because it is something that the county board had asked us for, to be able to recognize what the values look like side by side versus what we did and what the taxpayer did. The other piece of evidence, I believe we've sent up the Bellagio's asset listing, which is also in the information that was part of the evidence. We've just added a couple extra columns to show what our value is next to their value, because that was not in the evidence on the same pages. We just wanted to put it together. That's something the county board had also asked for, if they could see what we had done and they had done side by side.
Mr. Souza?
Mr. Chair?
Go
Chair?
ahead. Yes.
Yeah, this is Sam Taylor with the Attorney General's office. I would just like to note for the record that according to NAC 361-739, A new summary or extract prepared from evidence that was submitted to a county board in the first instance is not new evidence. Thus, you would not have to make a motion to accept it if you find that the evidence was in fact submitted to the county board in the first instance.
So let me hear from Mr. Souza, and then I'll make an observation, and we can go from there.
Thank you, Mr. Chairman. Jim Sousa for the record. Two things. One, if something was submitted last night, nobody gave me a copy, which would be professional courtesy to do that. So I have no idea what they're talking about. And they also filed a brief in this matter about 25 days ago, and it should have been included in there if it was going to come to the board so that I'd have a chance to see it. So not quite sure what's going on there. The second thing that they did was the asset listing from the Bellagio, which was actually used to prepare a valuation for the Bellagio. And I believe your counsel will tell you under the Nevada rules, you have to show that you could not have, by due diligence, have produced that evidence at the County Board of Equalization, when obviously you could have, because it was actually used to prepare the value that was appealed, that was heard before the County Board. So the time has come and gone for that, and we don't need several hundred more pages in a 10,000-page record that could have already gone into the county board record way back when. So we're objecting to the additional Bellagio asset listing or anything similar to that for any of the other cases because they don't meet the legal requirements, and legal requirements apply equally to everybody.
I suspect we'll hear more of that here in a few minutes. So if I understand correctly, and having done a brief review of the 205 pages that we received, it appears that it's granular detail regarding the assets that are listed in bulk in the original, in one case, 12,500 pages.
That is correct. There's, I think it's almost 300 pages, which is just the Bellagio's asset listing. What it shows is what the appraisal that the taxpayer provided, what they concluded to for the values, and then alongside of it is what our value was and what we concluded to. So it just shows them side by side as a comparison because it's something the county board asked for. So both sets of information are in there. They're just in separate locations. That's one piece of the information we sent up, and then the other piece are the manuals. It's the live tables from the personal property manual, which is part of the evidence that's in the record, and then the tables that were provided by the petitioner. And then the last piece has to do with the analysis that the petitioner provided, and then we also provided a response to that analysis that was in there with the minor addition of one column that just shows a difference between the values of what was in the table. It's just a calculation. So it is based on what the AG was saying, 361.739, a new summary or extract prepared from the evidence that was submitted to the county board in the first incidents, and it's not new evidence. So there is no new evidence in there.
Mr. Chairman, I'm kind of confused here because there's a lot of, there's not a lot. What there is that I see that I got on here, like case 23-118 of Bellagio, and then there's a 23-118 assessor new evidence number 2, and then there's a 23-118 new evidence full asset list. Are we talking about both of these as new evidence for that one particular property? And I think Mr. Sousa has a point to it. He wasn't provided this information. He didn't get this email, and I didn't see it till I think it was 11 o'clock last night.
Chairman, may I speak to that?
Please.
Mary Ann Widener for the Clark County Assessor's Office. There are two pieces of new evidence that was submitted timely to the board in the time frame that was required for us to submit it. I believe it's 7 days prior to the hearing. I think that's what it is. And what that is again, it's not even new evidence there. With each of the cases, what we've provided is the detailed asset listing. What was in the cases originally was a summary of the asset listing, but we just thought for the benefit of the board, if you needed to look at it, we wanted to provide the detail asset listing, and so that's what we've done. And it's several hundreds of pages long each. I think there's like 500 pages per case of the detail asset listing. So that's what one of the items there are. So we don't even really consider that new evidence, though we did submit it up under the new evidence provisions. The second piece is a response to some comments that were in the appraisal and I think made at the board with regards to the current market conditions of Las Vegas and the nation with regards to gaming. And so we've just included some indicators from the LVCVA, which is the Las Vegas Convention Authority, to show what the evidence of what's happened over the past 2 years with regards to the gaming market. And so if the board doesn't want to see that information, that's up to them, but we just wanted to provide it. We just thought that the asset listing would be valuable. The other thing that you asked me about originally, we did not submit as new evidence, and that is something we did send up last night, and that falls under the statute NAC, or the Administrative Code NAC 361.739, because it is a new summary or extract prepared from the evidence that was already in the record, and so it's not new evidence. We could argue that the asset listing is not new evidence either, because it's just the detail of the summary that was provided within each appraisal.
Thank you. Mr. Souza.
Okay, so now I think we have three things. The first thing is whatever was submitted last night, which I still haven't seen. No one's provided me a copy. Number two is the detailed listing of the specific assets that then fed into the valuation that was then summarized before the County Board of Equalization in materials that were there. So again, the legal standard is, why couldn't you provide the detail back at the county board? And if their answer is, oh, thank you, I just got this, thank you. I'll read all 40 pages quickly.
Well, then you're missing 200 of the pages that I got.
Well, I got those 7 days ago, so that was
Okay.
helpful. But it's the detailed listing, and the detailed listing could have been provided at the county board time. So the standard isn't whether it will be helpful to the board. The standard is, can you introduce new evidence? And your counsel hopefully will tell you that you have to show by due diligence it could not have been given at the time of the county board hearing. And there's been no explanation of that so far. As far as the third item, which is the Las Vegas Convention Bureau, sure, there's 2019, 20, and 21 and 22 data for a number of metrics that are in that information. I'm suspecting that almost all of it, if not all of it, could have been provided in the February 2023 County Board of Equalization hearing. And so there's been, again, no showing that it could not have been made available. So because the law applies equally to everybody, if it could have been shown in the county board, it can't be introduced as new evidence in the state board.
Thank you very much. I knew I would hear that phrase again.
It will come up.
I suspect. Board, do we have any comments regarding accepting this either as a summary of existing information or as new information, keeping in mind that the third item that was provided is not necessarily a summary of something that was provided during the county board hearing? That's the gaming metrics for the Las Vegas region. Gentlemen, this is the time for your input. Hello?
Thinking.
Mr. Sousa, what you indicated that the county has filed another brief or a motion or something that you haven't seen, or what are you specifically referring to? What's the date of it?
Sure. So the items which you received at 11 p.m. last night were just handed to me now.
Okay.
So I haven't had a chance to review any of this, nor do I know what it contains. So this is the third item, but the first two items were the asset listing and the Las Vegas Convention Bureau, which was submitted timely under the board's rules 7 days ago. And those we're arguing could have been submitted to the county board, and they haven't shown any reason why they weren't. And therefore, under the law, they're not admissible here.
I'm sorry, I thought you said that they had filed another brief that you hadn't seen.
Oh, I apologize. So they filed a brief in this matter as the petitioner's opening brief, and I said during that period of time, any information that they wanted to submit could have come in. They didn't submit this with their opening brief as a summary, and so that's why I didn't get a chance to see it until 7 minutes ago.
Mr. Chair, if I may.
Is that you, Tyree?
Sam? No, this is Sam.
Oh, hi, Sam.
Hi. Just for the record, Mr. Souza's characterization of new evidence is correct. And the one thing that I would note for the record here, that just try and maybe assist the board in making its decision, it sounds to me like there's 3 separate submittals, and you might want to consider each one separately and rule on each one separately, unless you find that they're all the same or similarly situated, just to make it easy and clarify the record. Does that make sense?
It does. Sam, if you could refresh my memory in gross terms, what are the 3 separate items? There's an asset list for the various properties that shows some granular detail and a comparison. That would be item number 1. Item number 2 is performance metrics for the Las Vegas region from the Gaming Control Board, I assume. And what's the third item?
I don't know the name of it. I don't know the title. Maybe the assessor can.
I think
provide you the title of
that
it.
if you page to the first page, I think you'll find that in fact is the detailed asset list. Am I incorrect?
You are incorrect.
Okay, then I'm looking at the wrong page.
Chairman Schiffmacher?
Yes.
Marianne Widener with the Clark County Assessor's Office. What we submitted last night, and I don't know if it came in 2 files or 1 file, but we submitted the asset listing for the Bellagio again, but the asset listing had the valuation done by the taxpayer alongside with what we do for our value. So we just submitted that because it was something that the county board had asked if we could do, if there was anything in the record that had something that showed what they did versus what we did. Along with that, we submitted the tables, which show the PTRS tables, which are what we're going to be discussing today, alongside of the tables from the personal property manual, both of which are in the evidence in the record. So all the information of all of the things I just mentioned are all in the record. Along with that, there is an analysis that was done that's in their appraisal. That analysis is also a page that's included in this, and all we've done is done an additional calculation on the far right of that analysis. It's a price analysis to show the difference between, to show some differences and some calculations that were not shown on that sheet. But the calculation was derived from information that was on that sheet. No new information was submitted in there that has not already been submitted within the documentation that is in the record.
Board, I'm looking for 2 pieces of information from you. One is whether this is categorized as new information that we would need to vote on, or whether if it is a consolidation or granular detail about information that we already have, whether we accept it into the record without a motion. Well, I guess that would be a motion.
Well, I'd like to ask Mr. Sousa a question. Sorry. Have you had an opportunity to even look at that document we just handed to see what the heading is or what's on it or what the detail is? Or
I scanned it briefly, but having worked with Ms. Widener in the past, I'm willing to accept her explanation as to what it is. And this is the 3rd document that we're talking about. There's 2 other documents, the Convention Bureau data, and then the several 100-page listing of specific assets for one of the casinos. Those are the other 2 items. So as I see it, the first two items have to pass the test in NAC 361-739 1A, and then the third item might meet the definition of not new evidence under 361-739-2, as your counsels pointed out. So it seems that we have to go through the first two items and then this third one as well.
Jim, if you would look at the package that you have in your hand, I see something that's, I think I'm on the same page. It's a PTRS price analysis, columns A through M, with some red headings that say market advertised price, RCN, percent good. Are we looking at the same thing?
We are.
Okay, thank you. And it's,
I'm not. Where the hell are we?
looks,
What file is that on?
so this was one of the emails
Yeah,
that we got. It is, it's, it's, is it,
Do you know what?
I'll provide an exception. You can bring that up. Hand it to Kelly to be logged in so that we know what we're talking about.
The only piece that isn't there is we didn't print it off because it was over 300 pages is the Bellagio asset listing that has the PTRS valuation and our valuation side by side.
And that's the granular detail, each asset individually.
No, that's
almost.
different. The granular detail that we've included for new evidence, which really we don't believe is new evidence, is our actual appraisal that we normally do on all assets for each property. We typically just provide a summary when we come to the board because it's so many pages long, but because of the arguments that went forward at the county board, we thought it would be advantageous to provide the detail listing to the state board so they would have that available to them. So all of the values, all the total value of everything there, it's just the, as you pointed out, the more granular of the summary that's located. I can show you where that is. Hold on just a second. The summary that's located on SBE 12465, it begins on SBE 12465.
We're going to have to, if we're looking at individual files, because each of those files is 10 to 12,000 pages, tell me what file we're looking at.
Okay, I'm so sorry.
And so with everybody's acceptance, let's pick one file to look at so that we're all looking at the same documents.
If we could look at the Bellagio, which is case 23-118, and we're requesting that one primarily because that's the one that they did the appraisal on, where they gave us the detail, and that was the one that was testified to at the county board. So if that would be beneficial, it would be the easiest one for us to look at.
So I have two files for, I've got a new information, which is a declaration of value detail, and which is only 500 pages, and then I have the Bellagio original file, which is 12,527 pages.
So of the 12,000 pages, if you go to page 12465,
Which is the Bellagio value detail summary.
correct, that is a true summary, and so it's summarizing based on acquired year and life, the items for the Bellagio. What we've provided as new evidence is just the detail of what all those items consist of.
Okay, so we're on, this is Tim Morse, so we're on file 23-118 Bellagio in parentheses, NOH parentheses. Is that correct? That's the one that we're going to stick with here?
Correct.
Okay, and then, so the new evidence part of that is the detailed asset list.
Correct. And again, if the board does not want to accept this information, we're not hung up as the county on what, it's not the crux of our case. We just wanted to provide the information because we thought it would be beneficial to the board to have the detail in case they had questions. If the board does not want to accept this new evidence, we're perfectly okay with it, but we would like you to accept the evidence that we are saying is not new evidence of the things that we submitted last night, because that is we're just trying to get us closer to not having to page through 12,000 pages of information and really argue some basic points of this case, so we're not here all day and all day tomorrow, because there are a lot of pages to it. It's really, what we've provided is to try to make it simpler for the board.
Mr. Sousa, I'm sorry, is this, whether we allow this information or not, I guess if we do allow it, is this going to hamper your case, since you haven't had a chance to look at it?
Yeah, it's not helpful, but I think we need to kind of take this in stages before we get too far into it. There's 3 items. The first one is the detailed listing of assets where the summary was provided to the county board. And I thought I just heard the county say it wasn't a big deal because we had the summaries anyway to have it in the record. And then we have the Las Vegas Convention Bureau gaming information, which wasn't in the county board at all and was available. So because both of those don't meet the statutory requirements, it seems like the board should deny the motion to allow those as new evidence. And then we have the third thing, which is certainly what's been handed to me, which was represented as already coming out of the county board, but then there was sort of this additional 200 pages side-by-side Bellagio asset comparison with other stuff. That just seems like new information that hasn't been provided at the county board and is now being done for the purpose of this matter. And that doesn't seem like a summary of what happened before at the county board. It seems like something new that they just want to do now, which would have been great to then have this some time ago. So that's kind of infecting my general desire to let the third item come in. I was okay with stuff that was just a summary of what happened at the county board, but then they said we also tacked on a couple 100 pages of other stuff. Now it's just all seemingly bad.
Board, any questions or comments?
Well, Mr. Chairman, let's take these one at a time. I make a motion that we do not accept as additional information the data provided by the Assessor's Office from the Las Vegas Visitors and Convention Authority, as that information was not available or submitted to the county.
Do I have a comment or a second?
I can second that one.
All in favor signify by saying aye.
Aye.
Aye. Tyree?
Would be a nay on it.
All opposed, so you're a nay? So motion carries 3-1. Tyree is the dissenting vote. Tim, do you want to take the second item?
The second item, I believe, is the detailed listing of all of the items. Am I in the right order here? To me, it's pretty helpful to look at this to see exactly what all of the items are and when they were acquired and what the difference is. I just don't know. Ms. Widener, if you summarize this and had columns breaking it out, and it would show like in 2022 what those items were, or no, I think in your case they're broken down into categories. So that would be, that's the same information that came from those categories.
Correct. It's what I pointed to on that 12,000, whatever page that was that I pointed you to before. It's what we've already provided. It's a summary. These are just the details. So if the board would like to be able to see the detail, it's there for you. If you don't want to see the detail, it's just up to you. We just wanted to provide it so the board would have access to it.
I make a motion that we accept this document, even though it's labeled new evidence. I don't believe it is new evidence, but I think it's very informative and timely and would assist us greatly in dealing with the issues in this case.
So, Tim, just for clarification, if you could provide a brief or a brief description of what you're actually looking at. Is this a 9 or 10 column page that's got two?
Mr. Chairman, I am looking at 23-118, assessor, new information, new evidence. Then on the front page it says State Board of Equalization lists all of our cases, and it says assessor additional information. The next page is Bellagio value detail, PTRS depreciated value, and the assessor's taxable value comparison. That's the 240-page document that I made a motion that we accept in this particular case.
Mr.
Chairman Schiffmacher.
Was that Tyree? Or
No, Sam again.
Please.
Yes, this is Sam Taylor with AG's office. I just wanted to inquire whether or not the board was going to consider all the asset listings for all the hotels since the cases were consolidated and will be used as a basis for making a determination. In other words, is that part of your motion, Tim?
Yes, sir.
Okay.
Yes, I'm sorry. I did eliminate that. We're talking about all 8 cases.
Okay.
Do we have that granular detail for all 8 cases or not?
No.
Yes, Chairman. I'm concerned, however, that we're looking at one thing and we're looking at another. What I just testified to is the detail asset listing. What I think Mr. Morris referred to is the additional information we submitted last night. I don't think that's what we were referring to. The one I'm referring to is 23-118. It says new evidence, and there's one for each individual case. The one for the Bellagio is 523 pages. And the cover of it says State Board of Equalization, case 23-118, detail asset listing Bellagio. And then it has Bellagio declaration of value detail on the next page, and then we start with the detail. And it actually has the account number, which is 117688 Bellagio-value detail at the top of that page. Page 4 of the new evidence.
It appears that we only have that level of detail for the Bellagio.
No, that's not correct. We've submitted this for each property individually.
I do not see that
It's
in
going to
my
be in
records.
each case. It'll be in each case. So this is...
All I received was one email yesterday.
No,
on
I'm not
this.
talking about the email from yesterday. I'm talking about the new evidence that was submitted in advance to the state board.
Yep. Mr. Chair, if I may.
okay.
Mr. Sam.
Excuse me.
Yes, Sam.
Yeah, just to let you know, I don't have that new document that you're talking about that you received via email. I don't have that. I don't know why. Maybe it's just because I haven't checked my email. I was out yesterday. But the asset listing, when I downloaded the files, they were in there. So it was part of the downloaded files, but I don't know when they're placed there. Maybe Christina could indicate when that evidence was placed in there, and it might not necessarily coincide with when you downloaded your documents for these matters. I think that might be part of the confusion here.
This is Christina Griffith for the record. So the full asset listings were placed on the FTP site when everything was originally placed on there. So you should all have that already. And it is, Marianne is correct, it is with each case. So it says the actual case file, and then right underneath it, it says the case number and new evidence in all caps, and then in parentheses around it, the full asset list. So those were the evidence that were received timely and placed on the FTP site, and then the other two pieces were sent via email yesterday.
Yeah, Mr. Chairman, I thought we were talking about, there's two documents are entitled New Evidence that are on 23-118, and I thought we were going to take, both of those would have to be discussed, and whether we were going to take jurisdiction and allow those. We were dealing with the first item, which was the stuff from the Convention and Visitors Authority. Then I thought we are dealing with these two other documents that are labeled new evidence, which the assessor's office says are not new evidence. And I thought we were going to take these one at a time. And that's
We're still trying to figure out make sure that we're all on the same page, because we've got documents coming from a variety of sources over a variety of times. And so I was able to find in my record the information that Christina was referring to that is part of the original package that we received, identified as new evidence. And then there are two additional documents that were provided by email yesterday that are also labeled as new evidence. And that in there is, that's where I have gotten confused. But I think I've gotten it clarified in my mind, what we're talking about. So that's one of them.
Just a reminder, Mr. Chair, you do have a motion pending and you need a second. You just need to clarify which documents it relates to.
That's what we're trying to do.
the document I was referring to was the one that I identified as a Bellagio value detail, PTRS, depreciated value, and then the assessor's taxable value comparison. The chart with the colors on it on the right-hand side.
Total of
That's
total of about 240 pages.
140 pages. That's part of your new evidence, is that correct, Ms. Widener?
No, that's the information that we submitted last night. That's not the new evidence. If it says PTRS tables on it, and it has percentages that show their value, and then it has the assessor's value, and it's in color on the right-hand side, that's what we submitted last night. It's just information we pulled out. It's in the record already, but we don't want to complicate things. We didn't intend to make this complicated. We meant for this to be helpful to the board, not harmful. So, again, if you don't, the asset listing, that's the new evidence. If you don't want to do that one, but this information that you're referring to, Mr. Morris, is information we would like to have as part of the information, because it also includes everything else that we want to refer to today that's going to be side by side, that will be easier for us to reference.
So again, we're referring to a document. The first line is item number 41204.
I don't have the document in front of me because unfortunately we don't have the one that we sent to you. It was pretty bulky for us to print out, so I don't have it directly in front of me to look at, but you guys have it electronically. But what we sent up last night was this, along with that asset listing that has the PTRS valuation on it. It is also in the materials already, and I can direct you to the pages that it is in the materials. It begins on page 170.
170?
170 in the Bellagio case materials. It's the same information that's listed there. We've just got two additional columns that shows what the assessor's value is next to what the PTRS value is. I believe two or three extra columns.
Board, any questions or comments? We still have a motion to accept some of the evidence, but I'm still unclear at this moment what evidence we're talking about. So, Tim, since it's your motion, if you would clarify.
Well, I'll withdraw the motion.
Chairman Schiffmacher, this is Christina Griffith for the record. I might be able to help clarify this a little bit here. So there's technically 4 pieces of evidence. The first one that you guys voted on already was the Las Vegas, the CVA, which was submitted in the email last night, and that one came in a batch that was I'm sorry, that one did not come in the email. That one was on the FTP site, and it was titled Assessor's New Evidence for all of the casinos, a separate file. You guys have already voted
So
on that one.
wait. That's the Reno or the Las Vegas Visitors Authority information, and we've already voted on that.
Correct. The
Next one would be new assessor, new information, new evidence, casinos, and it lists all of the properties. It says assessor's new evidence number 2, casinos, 23-117, 118, 20, or 120, 136, 137, 138, 139.
Correct. So that would be number 2, and that was one that was submitted via email to you guys last night. There is the
Yes.
there is new
So-
evidence that is the full asset list that is in each file for each casino. So that's listed separately for each casino, the full asset list. So that would be number 3. That one was received timely and should have been downloaded with the FTP information originally. And then there's number 4, which is the email portion that was sent for the Bellagio. That is the PTRS assessors comparison. Does that help at all?
Yes. Not enough, but it does help.
Well, my motion was to go ahead and accept that, and then Ms. Widener says it's not new information. So
Mr. Morris, yes, it's the detail. I just wanted to make sure that what you were asking me, I was answering the one you were asking me about. If it has PTRS information on it, we did not submit it as new evidence. The one that we submitted with the new evidence of the LVCVA stuff was the detail asset listing. We still don't believe it's new evidence, but we submitted it in that time frame, and it's just the detail asset listing. So I think that's the second piece. So if you just want to vote on that, and we have one of those for every single property that is being appealed here today. So that's, I think if you just vote on that one, whether you can accept that one, then that would move that one off the table, and then we could move on to the next one.
it's labeled new evidence, but then you don't want it labeled new evidence, huh?
If you want to vote on it as new evidence, we don't have a problem with it. Again, if you don't want the detail asset listing, or if you want to vote it and say, no, we don't want to accept it, we're okay with that too. It's just the detail asset listing for every single property. So if the board feels that would be advantageous to look at that, then you can vote on it to accept it. We didn't send it up as new evidence. We sent it up in the time frame that new evidence is sent up. We didn't label it new evidence. The department labeled it new evidence.
Mr. Chairman, I make a motion that we accept this document, whether it's new evidence or old evidence or whatever. Let's move on here. Good God. I make a motion we accept this document that has the Bellagio value detail, the PTRS detailed, depreciated value, excuse me, PTRS depreciated value, and then the tax, assessor taxable value comparison. It's 240 pages.
Do I have a second?
Mr. Chair, Terry Gray here. I second.
All in favor signify by saying aye.
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 Motion carries. That piece of information has been accepted for the record.
Chairman,
So, yes.
we don't have a copy of the 243 pages. It was never provided. So if we're going to have a hearing and they're going to be referring to it, it's kind of putting us in an unfair position.
Okay. Sam, your read.
Yes, Sam Taylor for the record. Mr. Chair, you've already passed a motion to accept it, so it would seem likely now that you would want to have a copy made up and presented to council for the Bellagio. In other words, if it contains information already received and already presented to the county board, then this is just a different configuration, and you're learning it as well as Mr. Souza as you go along. So, and the board's already moved to accept it.
Souza have access to the FTP site.
Can you accept information from the FTP site, or can you get it by email?
Both of those are available. I can get onto the FTP site from here. So if you can post it there, we can open it up and we can look at it while the hearing is proceeding. That would be acceptable.
Okay.
It is posted there.
Okay, so what's the label?
And this is the file that was
I'll get it
emailed
for you
last
while
night.
you're getting out there.
All right. So I just want to make sure that we can get it.
I would you too.
So we're on the FTP site, connect. I'm sorry to walk through this, but I have a phone that flips open, so there's only so much I can do. So
Can
new
we
casinos.
go off the record for a moment for the court reporter while we're looking this up for her, or for Mr. Sousa?
Yes.
So I opened where it said new casinos. I had a 3-page document. Okay. Oh. Okay. So is it preceded by the file number? Okay.
I do not see the information.
I'm loading it on there right
It's
this
not on the
minute.
FBT site. It's not loaded on the FTP site.
Well, she says she's loading it right now, so we have to just wait until.
Do you also have access to your email right now, Mr. Sousa?
I do, so can I jump in there?
This is Sam. Christine, if you're going to send it via email, can you send it to me as well? Because I don't have that document either.
Yes, sir.
So I'm in the, is there a chance you could send it? I'm on the email, is there a chance you could email that 200-page document? Yes,
I can email it to you.
could you?
Yes.
Okay, great. It's J.
Christina, This is Sam. Um, I don't really like to give out my email address over this.
No
is there
worries,
some way I can give
Sam.
you my personal email?
You can go ahead and email me if you would like. I have your work
Okay.
email address if you want me to send it there.
Yeah, but I'm not at work. I'm on my personal computer at home. So, and I, I guess I can. That's all right. Go
I
ahead and
can
send
load
me my
it to
work
either
address. I
one. The
can log on.
FTP site, it is loading on the FTP site as well right now too. It takes a second, so whichever way you would like it. If you have Teams, you can send me your email on there, or you can just email me what your email address is. If you have my email address.
Yeah, I just sent you an email, Christine.
Okay, and it should be in your email, Mr. Sousa. Okay, and you should have it now too, Sam.
Yeah, I don't see it yet. Yeah, still don't have it yet.
Christina, my email came through.
Okay, thank you.
Jim, do you want to look at it and make sure you understand what it is, please?
I would not even understand what it is, but they're going to look.
Fair enough.
Yeah. I didn't get it. So I-
Okay.
That's important.
We back on the record?
Christina, can you notify the court reporter that we're going back on the record?
Yes, she's aware. Thank you.
Thank you. Go ahead, Tim.
Mr. Sousa, now you've had 2 seconds to review 240 pages. Do you have heartburn over this? These are individual items that are listed. And as I talked about in my motion, was that there were categories that were put together that had totals on them. And it's my understanding now this is just a breakdown of individual items, and that those categories would have been included in the original information that was supplied to you and is information that is contained in the 12,000 pages. Only difference is the last column isn't on there that shows the difference.
I need a moment to consult with my appraisers. Can I do that?
Yes, sir.
Thank you.
This is Sam for the record. I did obtain the file.
Okay, Mr. Souza.
Yes, sir.
Your input.
Okay, here we go. So it's Jim Sousa for the record. My appraisers tell me that, one, we don't know all the information is accurate, but we're going to have to assume that it is. Two, these are new calculations that were done side by side for various things that we haven't had a chance to review. And there are calculations that are done that I guess would assist them in their presentation. So this all looks like stuff prepared in advance for the hearing, and therefore it probably should have been given to the board before the hearing as opposed to right today, because then we've just had no chance to review any of it. So we have concerns over it coming in. The summaries that they've done in the first couple pages, that's not really the issue. That's the 240 pages they've tacked on top of that that has a bunch of information on it. How do you respond to that in the 10 minutes you have before you have a hearing? So,
Same way we deal with it.
all right.
And
well,
we just got it too. I mean,
all right. Well, seems like dirty pool, but okay.
all right, so Ms. Widener, though, on page 240, let's say, there's no totals on those pages. And what you're telling us is that if there were totals on there, they would have the same numbers as contained in the petitions, and that is the cost new of a category item the index, the replacement cost due, and the depreciation to show what the taxable value is of a category. So if on the bottom of page 240, if you had totaled all of these, we would be looking then at those numbers that show the difference between your value and their value. Is that correct?
Yes, theoretically, that exactly is it should be true. I don't know why we didn't put totals at the bottom, but all we were trying to do, we just have an Excel version of what they submitted in the information in the case, which is on page 171, SBE 171 for the Bellagio. It's the same asset listing that's there where it shows the values that they concluded to with the P-TRS tables. We added the columns to show what we did, and we were just, again, we didn't know what questions were going to come up at the county board. So this is one of the reasons why we did this additional analysis, because what the county asked for is, can we see what you did and what they did side by side? Well, we didn't know they were going to ask for that. So that's what we did. We just tried to produce what they did and what we did side by side so the board could see the differences. It's not the crux of our argument. It's just there.
Excuse me, I understand that. I would
Okay.
just ask you a question. That question was, if you put totals on the bottom of this, it would have shown the same numbers that we're already talking about.
Yes, they should.
Do you agree with that?
Yes.
Thank you. Nice answer. Mr. Sousa, you have heartburn with that?
I have heartburn that we didn't get this 2 or 3 weeks ago so we could review it. If they had the entire summer to create it, why couldn't we get it 3 weeks ago? But you've already accepted the evidence, so I don't want to make this longer than it needs to be. I want to get to my motion to dismiss.
Well, we've got a motion. Did we?
Yeah, we voted on
We
that.
voted?
Yeah.
We have one more piece of information, and that's this one that has been submitted.
No,
This
the
is
other
different.
piece of information is per case, there's 500 pages of detailed asset listings when the summaries were put into the actual county board proceedings. And so that is clearly new evidence that could have been obtained at the county board, and it wasn't in the county board record, and that should be barred under the statute and the regulations requirements. We need to keep what the law says.
You're referring to the motion that just passed?
No, the 500 pages per is different than the 200 pages that we're talking about now. Yes?
So in case number 2318, new evidence, full asset listing, 523 pages. The heading on the first page of the spreadsheet would be 117688 Bellagio full value detail.
Correct. And there should be one of those in every one of the 8 files.
I see that. So we're in the same place, Tim.
Hey, we're on the same page.
Yeah.
Good God. All right, what do we do now?
To a certain degree, if we end up hearing this case, some of this information I think is illustrative and worthy of discussion. Historically, there's been a motion made to accept information like this and give it the weight and consideration that the board during the deliberations view is appropriate. That does not mean that it becomes the crux of the case. It means that we believe that it may be illustrative of certain elements of the argument. I don't know whether the board finds that type of a motion would be acceptable. I don't know whether our attorney finds that to be an acceptable format.
Mr. Chair.
Please, Sam.
Yeah, I think the threshold issue, it's been argued by the assessors that this is not new information. Rather, it is just another way to present information that had already been presented to the county board. Mr. Souza has objected to that. So the initial threshold question is, the board needs to determine, is it in fact new evidence? And if it is not new evidence, the board does not deem it to be new evidence, then it does not even need to take a vote on whether it should be admitted, because it is merely a summary of something that was previously presented. Thus, the initial threshold determination is whether it's new or not.
I'm not sure how to make that determination other than the assurances of the assessor's office.
Mr. Chair, you're entitled.
It is clearly in a different format than the information that's in the original file. It clearly has new calculations that could have been done at that time when the file was initially presented. So, Board,
Mr.
what's
Chair,
your feeling as to?
I don't feel it. I just wanted to clarify. You said there's new calculations. What I'm looking at, the 523 pagers, just a listing of assets.
Yeah, the calculations were with the document you just previously approved.
Correct.
There are no new calculations in the document you're dealing with right at the moment.
And I would ask
Chairman
the
Schiffmacher?
the county assessor, if the same question that Member Morris did is if we took the grand total of these 523 pages and compared them to summary from the original evidence presented at the county, the totals would be the same.
Chairman Schiffmacher, if you go to page 12466 in the case, the value detail summary, it will answer Mr. Plank's question.
What page was it?
12466. On this one, you will see there's totals at the top of the page. It shows acquisition cost and taxable value. That's our summary.
Wait. Let's get on the right.
12466.
Yeah. Okay.
It should show the value detail summary, and then there should be totals in blue, and it shows acquisition cost $556,163,894, and taxable of $164,888,794. Do you see that in blue? The header is 117688 Bellagio value detail summary.
Yep, 12.
So,
it's
So
really not-
wait. Marianne, if I'm looking at these two documents, it appears that the information that was provided as, quote, new evidence, end quote, is merely a reorganization of that information.
I wouldn't even say reorganization. What was submitted in the case was a summary of the information based on the year and the life. What we've provided you is the detail. So it's the same information, it's just the detail version of it. It's just breaking it out and giving you every detail of every asset. This one summarizes it that was in the case materials. What we've given you now is the detail. It's the exact same value. It totals to the same value. It's the same set of assets. One is summarized, one is not. We just thought the board might find it beneficial to have the detail.
Mr. Souza. Whoop, yeah.
So Ms. Widener is correct that this is the exhaustive 500 and some page detail for what is a couple hundred pages or smaller in the county board's record. So why didn't you introduce it as the assessor in the county board record, which is the legal standard?
That,
Yeah.
It's one mic at a time, so we don't get feedback, and so Carson can hear you fine.
I apologize.
Whoever
Let's
was
move on.
speaking, we couldn't hear.
Okay. Once more into the breach. This is Jim Sousa. The information that is contained in 23118 as new evidence is the 500 and some page line by line, asset by asset detail that was provided to the assessor's office to get the value that we had. In the county board record is the information and the totals are the same, listing those in groups such as gaming tables versus 740 gaming tables. So if the board wants to have the 500-page detail, they can do that. I just point out once again, the legal standard is, why didn't this show up at the county board as part of your presentation? And if it didn't, then why do you get to have it now? Which we seem to sort of be ignoring.
Board, I'm looking for your input. This is this is not the crux of the case. The crux of the case, I think, is going to be presented next. I'd like somebody to make a motion that we either accept this or don't accept it, and then we need to move on. We burned an hour on something on
Mr.
this.
Chair, I concur with you. Mr. Chair, this is Tyree Gray for the record. I would make a motion that we accept it. It appears to be evidence and information that has already been shared, that is being presented in a different way. So if here at this hearing, the county chooses to present it as a pie chart instead of a bar graph, I'm okay with that. And so I do believe that we can take it, we can receive it, and we can give it the weight that it's due as it unfolds.
Second. Aye.
All in favor signify by saying aye. Aye.
Aye.
Motion carries. Have we addressed all of the additional information? Super. The
Mr.
petition,
Chair,
yes.
it's my understanding that Christina referenced 4 documents. There is one document that she said was emailed that has not been yet voted upon. I don't know what the name of that document is. I do not have it, but she referenced it.
I thought we already decided on this.
Is that correct, Christina?
So I'm asking for confirmation from both parties. All of the information that we've provided, even though some of it came in last night and Mr. Souza got it an hour ago, we are going to allow all of that to be considered if we accept jurisdiction of this case.
I agree. Thank you. This is Mary Ann Widener from Clark County.
Jim says I agree.
Okay, so let's put that to bed. The
Can we just-
next
hey,
is,
Mr. Chairman, did you hear Sam's
Yes, sir.
concern? Did you hear Sam's concern that there might be a fourth?
I think
don't
that
know.
we've addressed all of the information.
Okay. Even the 22-pager?
I believe so. Oh, no, yes, the stuff from the Las Vegas Convention Visitors Authority or Gaming Control Board, the performance metrics, is that the document you're thinking of?
The one I'm thinking of, and I don't know, Sam was asking Christina which one it might be, but the one that I think it is the PTRS price analysis with the highlighted arrows and labels at the top. Is that the?
I think we've accepted that.
Okay.
So that's this one.
Sorry about this one.
Yep.
I think we voted on this one. Oh, yeah?
I think we did. Tim, if you think that we need to vote on it, make a motion.
Well, let's go. Call the case.
Okay. So Sam, refresh my memory. At this point, we have a motion to dismiss. Is that to be heard in what order?
This is Sam Taylor for the record, Attorney General's office. It would be the person who made the motion, which is de Blasio.
Okay, Mr. Souza? Go ahead, Sam.
No, I thought I just said it should be Mr. Souza.
Very good. Mr. Souza, This is, I think, the crux of the beginning of your case. We have all read the information. If we could try to move on, but I'm going to give you the time you need.
Thank you, Mr. Chairman. Jim Sousa for the record. So because we've consolidated the cases, the testimony and the arguments will be the same for all the cases, so we're going to do this once. We, in fact, have submitted a motion to dismiss, and I have the RE as SB record, and our motion is starting at SB 12. And
So we're going to switch from the Bellagio file to the ARIA file?
try not to. I'm scrolling through Bellagio right now, and I'm pretty much thinking it'll be in the same place.
No, it's on 14.
Well, then I was wrong in thinking it'd be in the same place. You're right. It starts on 14. So I'm not going to go through that. You've read through that. You've had the opportunity to look at it. Arguments were raised involving the submission of the appeal files or the appeals that were sent in by Clark County. And so I just need to be very clear here as to what we're talking about. In the earlier cases, we talked about when the county board hearings occurred and the people having the opportunity, sufficient time to submit the appeal forms. And as you noted, everybody has responsibility to sort of follow how their particular matter is going. And if you find out you're going to be appealing, you have to get the appeal file time. That seems to make sense to me, and that was the board's earlier holding. So
Mr.
in this
Sousa,
situation,
I'm sorry, if you could please repeat the last 30 seconds of your testimony. We lost sound.
If I could remember it, I'll try. So in the prior cases, we had a discussion of everybody tracking their own appeals and knowing when their appeals had been concluded, and if they were going to file an appeal from the county board to state board, that they had a certain deadline to do so. And so that's a good rule, and it applies equally to everybody. So in this case, we had the Clark County assessor having the hearings on February the 27th, losing in each one of these cases, and making a decision to appeal. And they quickly, by March 2nd, a few days later, completed appeal forms and submitted them to the State Board of Equalization. Unfortunately, in that hurried motion, they used the wrong appeal form. The State Board's website is very clear that they have specific forms for specific purposes, and there are taxpayer appeal forms, and then there are assessor appeal forms, and they use the taxpayer appeal form. So as we've briefed in our pleadings, that doesn't count as a valid appeal because there's a requirement to use the proper appeal form that the State Board has issued, and that would have been the assessor appeal form. In addition to that, there was also the issue that on each one of those March 2nd appeals, the form was signed by an individual, and where they signed in Section H of the actual appeals, there is some language which is somewhat very important, and that language states that you're declaring under penalty of perjury that you are the property owner or that you're an employee of the property owner, and therefore you're filing the appeal. Well, obviously, in neither case is the assessor's employee meeting that requirement. So in the earlier cases we had today, which I thought were very instructive, we saw appeal forms that were filed on the proper appeal form. And I had the opportunity to look at those when the FTP site became available. And I also noticed that the person who signed those appeal forms was the tax agent. And so had the secretary received those appeal forms timely, they still would have been defective because the person who signed it was not the employee of the property owner, nor were they the property owner. They simply were an agent. And so that was done improperly as well. So it's our position that the original March 2nd appeal forms were done on the improper form, which violates the statute, and they were signed by a person who didn't meet the requirements, and therefore it's an invalid signature. And if you submit a form to the government and you're not the person who's allowed to sign it, then it's like you didn't submit a form to the government. It has no valid effect at all. Then the assessor received notice that their appeal forms were incorrect, and they then filed the proper form, and they filed it the same as the cases that were heard before ours on the same March 15th date. And so that would then been untimely. So if they had filed the correct forms on March the 2nd, even though they got most of the information that they put on the form wrong, they still would have had a valid appeal, but they didn't. They filed the wrong form timely and the right form untimely. And so as I watched the 24 cases that proceeded before ours, I said, this sort of seems like our situation as well. And when the board held that the person should not have jurisdiction in front of the board for each one of these appeals, that seemed like the right result. And I would point out that, our briefing is basically that the rules apply to every person equally. And had the taxpayers been the ones who had grabbed the wrong form or had filed after the due date, as we found out here, we would have been barred from this board having jurisdiction. And I remember hearing I think it was the very first case, board member Gray mentioning that, there has to be some equity here. And the equity to me here is that everybody has sort of the equal application of the law. And I understand that Board Member Gray is in Washington, D.C., perhaps on business, and I would recommend to him going to the United States Supreme Court building, which is located right behind the U.S. Capitol, and you'll see 4 words, very important words, engraved deeply in granite, saying equal rights under the law. Equal justice under law. Sorry, that was 5. So all we're asking for is equality. Had we been the taxpayer, grabbed the wrong form, we'd have been bounced out of here. Had we been the taxpayer, submitted the right form too late, we'd have been bounced out of here. And the assessor is now saying, we did all those things, but we don't want you to bounce us out of here. So that seems to be the problem. We ask for equal application of the law. And we think that we've provided all the basis in both our motion to dismiss and then our reply, which addressed all of the arguments raised by the assessor's office. And that's all I have.
Board, at this point, are there any questions for Mr. Souza, keeping in mind that we have the assessor's presentation and then a 5-minute rebuttal? So do we have any questions for Mr. Souza at this stage?
None for me.
Tyree? Tyree?
None here, Mr. Chair.
Tim?
No, sir.
Okay, this is the assessor's opportunity to rebut that argument. You'll have 15 minutes subject to questions and comments from the board.
Thank you. Lisa Logston from the Clark County District Attorney's Office representing the assessor. This is a pretty clear one. The county filed timely. Granted, it might have been on the wrong form, but there's case law out there that when it's form and content, all you need is substantial compliance. So the appeal was timely, and which is what's required under the statute to be received by March 10th. It was received on March 2nd. The attempt to misconstrue the fact that it has to be on a particular form isn't supported by case law in Nevada. The form and content provisions dictate that content-based rules are directory, so they're and can be satisfied by substantial compliance, and that's to avoid harsh and absurd and unfair consequences. So in this case, I think it is an equity thing, and the county makes mistakes just like taxpayers make mistakes. And the fact that the county put it on the wrong form isn't jurisdictional. It was timely, and this board has the jurisdiction to hear this case. And this happens all the time at the county board proceedings as well too. And we reach out and we have the taxpayer submit the correct information on the right form. So this is not like the cases we heard earlier where maybe something was not submitted timely at all, or because it's really the timing piece that is the jurisdictional piece. The substantive of what's on that form is within this board's discretion and to determine that substantial compliance with the process has been completed. And that's to ensure that equity is served and that it is to avoid any harsh or unfair consequences that can occur.
And Marianne Widener with the Clark County Assessor's Office. I just want the board to be aware, because some points were made within the brief, maybe not testified here today, that the county would have rejected this kind of form had it been sent to us, and that would be an untrue statement. We get appeal forms that are on the state forms all the time at our county board hearings, and we do the exact same thing that the department did. We accept the appeal and we send them the correct form to ask them to fill it out just so we can get the right information in the right location and get it in our system correctly. But we have had that happen quite frequently, and it's happened multiple years, and we have never rejected any of those appeals that have been given to us on the wrong form. We just simply take that and then send them the correct form and ask them to fill it out. And none of those have ever been scheduled for a notice of appearance, ever. Thank you.
Tim, you have experience on the County Board of Equalization. I'm not sure you had it under when Ms. Wagner was the assessor. It may have been under the prior assessor. Is that consistent with your experience?
Well, Mr. Chairman, I have had experience on both sides as far as being on the board and then also dealing with the assessor's office when I've been retained by taxpayers to file appeals and file documents with the assessor's office to get it scheduled for a hearing. Unfortunately, the Clark County Assessor's Office has been very, very difficult to deal with in putting the agency forms together, and they go to the Secretary of State's website and double check the names, and then come back to people and virtually require you to go get a corporate resolution from the property owner saying that they have given you the authorization to represent them. And their paperwork has been very extensive and tenuous and difficult to deal with, and has been very complicated and made it very difficult for people to file appeals before the Clark County Board. So I have a couple other questions I'd like to ask, if that's okay.
This is your time.
In the opposition motion to dismiss, SBE 69, I'm looking at 23-118 Bellagio, in parentheses NOH, which is the notice of the hearing. This is their case. This is the motion that the county assessor filed in opposition to Mr. Seuss's dismissal. And on page SBE 69, it states that the I can't find it. I had it highlighted on here. Now all of a sudden the highlighting is gone. But as I recall from my notes, it says that the assessor's petitions were all filed. Yeah, here it is. Additionally, petitioner timely submitted them prior to the March 10th deadline. Can you explain that to me? Which document you're referring to? Because I take that you are talking about the corrected file, the corrected petition. You're telling me in this particular document that it was filed prior to the March 10th deadline.
I think as the record reflects, the assessor submitted the timely filing on March 2nd. Granted, it was an incorrect form.
They filed an incorrect form
On March
the 2nd.
Correct.
On March the
I believe it's the
15th, there's an email in here that says you made a mistake, file a correct petition. Is that correct?
That is correct. I think that email is in.
The email states that you made a mistake, and then the assessors people resubmitted it. The petitions are even signed March 15th.
On the corrected forms, but it was
Right.
timely. The request to appeal was timely submitted to the state board on March 2nd. Granted, on a form that was titled taxpayer versus assessor.
Well, this says that the petitioner complied with a substantial essence of every reasonable objective, et cetera, as articulated. Petitioner retrieved and only completed the forms from the website. Additionally, petitioner timely submitted them prior to the March 10th deadline. So are we talking, what I think that says is that the corrected petition was filed before the deadline. And that's not true based upon the emails that are contained in this document, that the assessor's office notified MGM the state notified the assessor's office that there was a wrong document.
Correct. I think what that statement says is the petitioner retrieved and fully completed provided forms from the SOB, from the state board's website. Granted, we pulled the wrong form down from the website, but they were completed on March 2nd and submitted to the state board. That's what that sentence is saying. As detailed above, the petitioner submitted a state board form on March 2nd.
So your argument here is that that submitting the wrong form complies to the substance essential to every reasonable objective, even though the form is incorrect.
Correct. That's substantial compliance with to invoke the board's jurisdiction.
So your argument is that almost anything filed before the deadline functions as a placeholder for future filings?
I think anything filed on a state board form invokes the board's jurisdiction. That, you put two forms out there. If the person picks the wrong form, I still think that the intent is there to invoke the board's jurisdiction. And the courts have found that substantial compliance with that is enough to invoke jurisdiction of a governmental entity.
And you've provided assurance here under oath that had this occurred at the county level, that this in fact is the course of events that would have occurred, that the property owner or the assessor would have subsequently been given the opportunity to refile the corrected form after the deadline.
That is correct. And this is Mary Ann Widener with the Clark County Assessor's Office. I just want to make a distinction because I know Mr. Morris did call out the issue with the agent authorization. So an agent authorization is different than a form. The agents are required to file an agent authorization, and they have a certain time frame to do that after the forms have been filed. But we have had individuals file on the wrong form. And so we've in fact had agents copy forms from prior years. They're not even, the wrong dates on them. There's not even a way to put the right year on them. They've just copied the forms, filled them out. We accept it, we just send it back and say, please fill out the correct form. But they still have to have the agent authorization to us in a timely basis, and that's the one that we do a lot of the critiquing on. Because if an agent signs the form, they're not the owner of record, so they have to have an agent authorization. I will say that the standards for what we're looking for have changed. We're not as strict as maybe we were 7-8 years ago. I can tell you over the past 5 years, for sure, we have given every kind of difference, and we have reached out and contacted people, and this was actually after legislation was passed that requires we give 5 days for an objection objection, and the 5 days for an objection to say is you didn't give us the proper authorization or you didn't identify who the proper owner was, and we give them that time to resolve that, but they still have to have filed timely. So things have changed dramatically, I think, from the time when Mr. Morris was actually functioning, you know, on the other side of the table, you know, defending taxpayers' rights, and which is perfectly admirable. But I just want to make sure the board is clear that those are two separate things. When it comes to the form, if they fill out the wrong form, we send them a new form and we ask them to fill out the appropriate form. And we've had multiple times where they have filed on the wrong form, both state forms or previous forms from our previous years where they've just, you know, erased things and copied them and sent them off to us again. And we absolutely accept those.
Okay, so you find a form that doesn't comply with your standards and isn't filled out properly and has errors on it. You still accept those?
We have errors on them all the time. We get errors on forms all the time. It's a regular occurrence. But if there's information that we need that they haven't provided, we continue to try to reach out to them to get all the information we need. But if they have filled out the form and they have signed it and they are the owner of record, and we accept that, even if it's one that went to the state. And the state could probably even, Christina maybe could even testify to the fact that they have received them and sent them back down to us. Because sometimes they send them to the state and then they send them back down to us because they've actually sent them to the wrong location. So it does happen as long as the material facts are there that lets us know what parcel numbers, the basic identifiers that are required on all forms. We know who the owner is. We know who the owner is that's signing. They've identified the parcels that are under appeal. The things that are important for us to understand, we will send them back the appropriate form and have them fill that out.
This is
How about
Christina
if
Griffith
there's,
for the record. Sorry, Tim. Yes, Marianne is correct. We do accept the same here at the state. They did submit filing timely to us, and I did ask them to submit on the correct form. And this does happen frequently with other cases as well, where it gets submitted. It is similar information on all of the forms, so it would not change the outcome either way. But we did get it submitted to us timely on March 2nd. That email in there is my email back to them requesting it be resubmitted on the other form, and we would consider it timely, just as the county would. Taxpayers submit the wrong forms all the time, and we have to ask for corrections, but we accept them when the original gets submitted, if that helps clarify anything.
Well, the corrected form then, according to the information submitted by Mr. Sousa, still contains 5 errors on there. That's outlined on the page 17, SBE 17. There are 5 errors that were outlined and discussed on the new form, and they are those errors then also harmless errors, and or is that just more sloppy work from the assessor's office and hurriedly filing a very important document? I'm just really concerned with that. We have an incorrect form that was utilized, and then we have a revised form that still contained 5 errors on it, that maybe that document shouldn't be accepted with that many errors on it that outline the problems with that document.
Tim, I think you were referring to pages 18 and 19. Not the page you referenced initially was the original filing.
Oh, yeah. Yes, Mr. Chairman, you're correct. There's still mistakes on the second form, and those are outlined on page 19.
What was that? Was that in the form of a question to the assessor's office?
Yeah, I'd like to know if the shoe was on the other foot, would they still be dancing the same song?
As I have already testified, the form is not as important to us as who signs the form and if they give us the appropriate information. So the county would accept the form and we would give them a new one and ask them just to fill it out properly. There are times when we don't even get a response on that, particularly from, like a typical residential, maybe homeowner, maybe an elderly person that's confused on how to do it, but we still accept it and we still move forward with the appeal. As long as we have the substantial information that is necessary for us to know that this was the owner of record and they've identified the items that they want to appeal and the years they want to appeal it. The whole purpose of giving them the form is because the state board approved the form and we're trying to put it in the format that the state board has approved. But there's nothing in the law that says that it has to be on a specific form. It just says that it has to be, you see, at least when they filed at the county, it says that it has to have certain information, including identification of the property that's being appealed, the reasons for the appeal, the owner, and some contact information and a signature. So, if it has that information, obviously we don't want people to go willy-nilly and start making up their own forms and things like this. There's a reason for a form. We're just saying that we have never rejected the form because they didn't use the right form. If they file something untimely, we will then send them back the appropriate form and ask them to fill it out, just so we have all the right information in the right places.
And if they filed that subsequent form with incorrect information, you still would accept it?
We still accept it. And I have the White Pine assessor here that can testify to the fact that they do the same thing in White Pine County, if that is helpful to you to make sure we're doing this equitably across the state.
Let's hear from Mr. Sousa. I don't hear.
Yeah, we'll take your assertions. Let me ask a different question, then we can go to Mr. Sousa. So in Section D of our agenda, which was the section that we accepted jurisdiction on one case, which was 23-143. That was a case where it appeared that there was ongoing communication between the property owner and the Board of Equals or the assessor. And the intent to file the appeal appeared to be fairly well documented. We accepted jurisdiction on that case and remanded it back to the county to solve the problem. The balance of the cases that we did not accept jurisdiction for, those were ones where the petitioner was radio silent until after the filing deadline. So your argument is that this case falls into the former, where there was notification, as Mr. Versilia, he had been in almost constant communication with the assessor's office or the county board to get the proper form, and he just was unable to perfect that communication.
He testified to that. I had no evidence that we could go off of to say that he had done that. The board accepted his testimony, and so we're going to accept his testimony because the board accepted his testimony. But I had nothing in writing. If I had had anything in writing of indication of that, I would have absolutely made sure that we had scheduled him for a hearing.
So, he appeared to have contemporary records, and so that's the reason that we accepted that
Yes.
Case. So what you're arguing is that if we were to compare this case in front of us right now to those cases from Section D of our agenda, that you would fall into the same category as Mr. Versilia as opposed to the Circle K tax reps?
Correct, because Circle K truly did not file on time on any form. But
So they were radio silent until the 15th.
that's correct.
Okay. Tim?
Mr. Chairman,
Or-
it was just an observation. I don't know if the timing of this is correct or not, but in one of the other cases that we have yet to hear, but I was reviewing, there is such a case where the intent to appeal with all the pertinent information was in email form, and there was a response back, and it was timely. There's an email back from the assessor that it was after the due date, but it stated, we're going to accept your email, as timely filed, and we'd like you to fill out this form. Here's where you can find it. So I guess my point is what we're trying to figure out is, would there be leniency if the shoe was on the other foot? And I think this is an example of that.
Thanks, Al. Mr. Souza, you look as though you have something that you would like to share.
Sure. So Jim Sousa for the record. So I'm a lawyer, and so I like to actually read statutes and administrative rules. So when the county talks about, well, this is what our practice would be, and I just don't care. All right? I want statutes and administrative rules. And what's funny about this is that the district attorney's argument used the term, this is a time and manner situation, and thus you can have substantial compliance. So even if it comes in close, we should count it as good enough, right? We all heard that. I'm sorry, she said it was a form and content case. But this is a time and manner case, and we said that in our brief, and on page 68 of this Bellagio record, the assessor writes, respondents correctly attach time and manner attributes to the statute and regulation. The statute requires a time to file, and it requires a manner to file. And they quote the regulation, on the form prescribed by the state board. And then the assessor says, however, petitioner complied with these requirements. Well, no, you didn't. And this is time and manner. And in Nevada law, time and manner is strictly construed. So if you make a mistake on time and manner, you didn't meet the requirements. That's it. This whole strict compliance and anything harmful and anything else like that that they're going through is irrelevant. It's strict compliance, time and manner. Did you meet those? Answer is yes or no. And in the first set of cases, we had a time and manner case. The person filed after the time. We applied the rule. So why aren't we applying the time and manner rules to this exact same situation? On the form prescribed by the state board. Was this the form? Let's take a look. It says right across the top, taxpayers petition for appeal. Apparently not the form. On the form prescribed. Therefore, you don't have a valid appeal. Was it signed by somebody who had the authority to sign the petition? Wrong again. It says, I'm the owner of the property. I swear it under perjury. Or I'm the employee of the owner of the property. None of those things are true. Therefore, you have an unsigned form. We heard stuff from the department about, we the department review these, we the department put some of these on the consent agenda, we the department do this stuff. Great, do your job, but that doesn't change this. We, the taxpayer, get the right as the respondent to point out they made a mistake. They didn't follow the time and manner rules. They don't have a valid appeal. Period. End. Done. So if we can bounce all these other people out at Circle K because the form was signed by somebody who didn't have authority and they submitted it after the due date, then why do we not bounce these people out as well? And the only thing you've heard from the government today is, let's apply a different standard for the government, right? Let's have some leniency. Let's call this not strict compliance, but substantial compliance, which is the wrong form. But they've admitted this is a time and manner. Time and manner requires strict compliance. It's right there in their brief. And if it requires strict compliance, you didn't meet it. You're done. So this is real simple. The law either means something for everybody or it means something for some people, but other people, they get a different interpretation. And we think it means the same for everybody. Equal justice
Mr. Chair?
under law.
Sorry, Mr. Souza, I apologize. I thought you were finished.
No, I was working on it. So that's what we think is the reason why the motion should be granted. And if the motion is granted, then we don't have to go through 10 valuation cases or whatever it is. But at the end of the day, they messed up. Next time they should take more time, right? They didn't have to file on the 2nd. Could have waited to the 8th or 9th and got the right form and done it correctly. It also would have helped to fill it out properly. Almost everything on the form they did wrong. And then when they submitted the revised form untimely on the correct form, they did a lot of that stuff wrong too, which is why I got a notice of hearing naming a tax agent as the respondent instead of the actual property owner. Everything about this was done incorrectly. and yet they're saying, we'd like a pass. These things don't apply to us. Let us have our day. We ask you to grant the motion for that reason. Equal treatment under law.
Sam, you were going to weigh in?
Yes, I just wanted to point out something with respect to the NAC provision at issue here, which is NAC 361-701, subsection 2, which Mr. Souza is citing. And the language states that the petition must be on the form prescribed by the state board and must include for the property in which the petitioner is appealing the valuation. And then there's a semicolon, and it's followed by subsection A through subsection N. And that information, it's my understanding, is the same for both forms, both the taxpayer form and also for the form that the assessor utilizes. So I'd just like to point that out for the record and have the board take that into consideration when they're making their decision, just to inform the board that the language is more extensive just than the use of the form itself. It also prescribes what must be on the form for both forms, both the taxpayer form and the assessor form.
Thank you, Sam. Tyree, you're the only lawyer on the board, and I'd like you to weigh in, please.
Happy to do so, Mr. Chair. Tyree Gray here for the record. So there's citation back to our prior decisions today, and I think that our prior decisions that have been made today, the facts here are different than those, but there are some instructions that can be gained from both of those. What we have here is we have an appeal by the government. The government is a sophisticated party. The government, in theory, though usually probably the one that is responding to appeals does occasionally appeal itself. Clark County does this every cycle. And so at one level, we look at Clark County and we say, how do you get this wrong? I understand that. On the second side of it is the equity idea for the person who is going to be subject to have to come to court and defend himself. In this case, this would be ARIA MGM et al., if you will. And the question is has MGM's ability to defend itself somehow been compromised, harmed, or impacted by the fact that the county filled out the wrong form? I think earlier we talked about the concept of actual notice. It said, if you get actual notice of something, whether or not that notice comes in the form and the substance that we would prefer it come in, are you at least put on notice that you are going to have to defend, you are going to have to act in some way? And so I guess my question and my comments are, it appears that despite the fact that the county errantly and possibly even egregiously filled out the wrong form, how has it impacted MGM's et al.'s ability to come today prepared to defend itself? And my analysis would be that they are unimpacted, and really are looking at just, is there an opportunity for this to go away because of the untimely filing on the proper form? I'm not persuaded that this is a manner case. I am more persuaded that it is a manner and time case. I'm not persuaded in that. I'm willing to be persuaded if there were more argument to that, but I don't really see how MGM et al. Has been harmed in the fact that this was filed timely. It was reviewed by the state, and the state said, hey, you guys got the wrong form, and it was immediately turned around. Now, are there errors on the form that was filled out? Yes, there are. And I mean, as a person who's clerked before, litigated before, and had the opportunity to be part of the legislative process, many times when you get those documents that have various errors, people will seek leave of the court in order to correct some of those errors. And those are usually not found to be held against somebody from a statute of limitations perspective, even. So it would be my thought that we would exercise jurisdiction of this case, have the opportunity to hear it on its merits. And being that MGM et al. Has prevailed at the county level, see if the county can carry its burden of proof here before the state. So those are my comments, and I'll be quiet and see if anybody has any questions or additional comments to add to what I've said.
Thank you for your input. Tim?
Well, my additional comment is in the case of the cases, items that we were going to that we had on our agenda here were the that we said we weren't going to hear because the Circle K stores. We weren't going to hear those because the tax rep didn't pay attention, didn't know about it, and that was a sophisticated user of the system, and they should have known how to deal with it. And since they didn't comply with it, then we're not going to hear it. So here we're dealing with Clark County Assessor's Office, the largest assessor's office in the state of Nevada, has most talented bench of people working at it that I've ever encountered. And we're dealing with a very substantial taxpayer, largest employer in the state, and the Clark County Assessor's Office blows it, puts it on the wrong form, then submits the form, and tells us that it was timely. Again, I'll refer to that page in the document that the county filed regarding the petitioner retrieved and fully completed the provided forms from the SBOE website. Additionally, petitioner timely submitted them prior to the March 10th deadline. And as we went through the emails from the assessor's office and the signature based on the document, they were not submitted prior to the deadline. The corrected form was submitted after the deadline, and the corrected form still has 5 errors on it, which is very sloppy, unprofessional, and I'm just shocked that the county assessor would come before this board and tell us, doesn't matter, even though that the statute clearly says the form. It doesn't say a form, it says the form, and that's the form that was approved and should have been used. The assessor's office used the wrong form, filed the appeal, and then comes back with a correct form and still has 5 errors on it. I just find it very unprofessional, and I'm just shocked at the assessor's office for their performance in dealing with this particular taxpayer. As a matter of fact, I'm embarrassed. I really am for the way that the taxpayer has been dealt with in this particular situation. They were the form's wrong. The correct form wasn't filed according to the right deadline, even though their attorney's telling us that it was. I just find there's too many mistakes on it. I just don't think it's reasonable that we should proceed with this because of all of the errors and mistakes that the county has made. And now they want to just come back and tell us, it's okay, it's harmless. Let's hear this case. We're talking about a substantial amount of money, and a lot of big properties, and I think it should have been handled completely different, and I'm not willing to support any motion to hear this case.
Mr. Chair, Tyree Gray here for the record. I know we may not be in deliberation period, and so if I'm out of order, please correct me. Tim, what I will say is where I find distinguishing nature between the Circle K case and this particular case is in the Circle K case, Circle K, again, sophisticated party, does not engage in the process at all. They file an appeal to the Clark County Board of Equalization, and then they don't participate. And then not only do they not participate, then they don't even take the time to find out what the result was at that level, and then come to us delayed and seek our assistance. And so where they maybe got the right, at the county level, got the right form, are completely silent throughout the process, through the board hearing, and completely silent and derelict within the process, even after the fact, until they receive actual notice. Where I see a bit of a distinction here is by nature of the appeal being at the county itself did participate. The county then goes on to file a form. Does the county have egg on its face, and should there be a discussion within the continuing learning element of the county in regards to which forms we pull by all of their various agency? Absolutely yes and correct. Yet something was filed, sloppily filed, maybe not well filed, errors throughout it. Something was filed. Not only was something filed, but upon receiving it here in our office, they were given notice, hey, you guys filed this, and you got most of it. The issue, the items are on here, but guess what? You used the right form. And then they turn around relatively quickly, again, making the same errors, if not additional errors, but there is actually something filed. And the concept in the way that I interpret it is the concept behind filing a document is not so that all of the arguments are laid out within that document, but it is to give notice to A, us, the body, and then B, those people who are to participate, that this is going to happen, which is why we're allowed to accept evidence of items 7 days before we actually have the hearing. There's a time period where if you need to go back and correct or supplement or provide, that you're able to do that, because there is a recognition that, okay, this document that starts the process is not actually the process. And then ultimately, when you come to us, we are then to take those facts, we are to take the evidence that is presented and to then render a decision from that. And my question, I guess, and again, Mr. Souza could answer and say, yeah, we've been harmed. But the truth is that the harm is not actual in its ability, in MGM et al.'s ability to defend itself. It is more, hey, these are the rules of the game, and somebody has not played 100% by the rules. Do we kick them completely out of the game? And so, to where Mr. Souza earlier talked about the concept of equity, I would argue that equity does need to apply equally to everyone. And that even sometimes means the county and or the government and or other sophisticated parties, when they are at the table and they are making an effort, even if that effort is poor. And frankly, as you said, Tim, the county should be somewhat embarrassed by what it has put forward, but they did put something forward.
Tim, did you have a comment, or can Mr. Souza reply?
Well, Tyree, the only difference I see really in these Circle K cases, and I think that was one of the things that we discussed, was that the people representing Circle K were familiar with the process, they're experienced, they've done it before, they've been down this road, they've filled out forms in other states, and they were perceived as competent people that could handle this kind of a transaction, and they failed to do that, and that's why we turned them down. Part of the reason why we turned them down, and that's my point here, is we're dealing with the Clark County Assessor's Office, not some tax agent that might have had the wrong form. We're dealing with the Assessor's Office that submitted the wrong form, and then when they submitted the right form, they still made a bunch of mistakes on it. So the statute, I think it says the form. It doesn't say a form. That's part of what Mr. Seuss has been arguing here, is that there's a particular form that was prescribed by and approved by and should have been used. And here we're dealing with the Clark County Assessor's Office, the biggest gorilla in the room other than the people that own all the hotels, and they screw up and do it wrong. But then their attorney points out to us that they submitted them on time when that didn't happen, in my opinion. So again, I don't want to belabor all of the points again, but all the mistakes and everything that the assessor office made. But in comparing it to the Circle K case, I thought we were talking about sophisticated tax reps that are familiar with the process and have experience and expertise in dealing with these issues and should have done it properly. And that's what we have here in this case, in my opinion.
Mr. Chair.
Was that Sam?
This is Sam. I'm sorry. This is Sam.
Go ahead.
Thank you, Mr. Chair. This is Sam Taylor for the record, AG's office. I would just like to clarify with the chair as to where we're at in this process. Are we still in the hearing phase or deliberation?
We have not closed it for deliberation. There have been a series of comments that may be construed as deliberation, but many of them take on the form of a question that can be answered by one or the other of the parties. And so we are kind of in a limbo at this point, a middle ground, because there are still questions that appear unanswered. And I think what I'd like to do is go to Mr. Souza and ask that he answer. He seems to have a question that he's ready to answer. I'll go back to the assessor's office, and then I'd like to close this and we can deliberate. Does that answer your question, Sam?
Most certainly, Mr. Chair. Thank you.
Thank you. Mr. Souza.
Mr. Chairman. Mr. Gray, I would ask you to look at the record in SB 16, which cites the Nevada Supreme Court's decision in Markowitz versus Saxon Special Servicing from 2013. Quoting the Nevada Supreme Court, time and manner rules are when performance must take place and the way in which the deadline must be met. What do the statutes and regulations in Nevada say? The way to meet the deadline is to file the form available from the state board to appeal your particular action. We have the assessor direct appeals, we have the assessor appeals from county board, we have the taxpayer direct appeals, we have the taxpayer appeals from the county board. So you get to pick which form is the right form for you, and then you have to submit it. That is a time and manner rule requiring strict construction. So I understand from perhaps your work history that there were certain things that you were trying to do, but this is different. This is filing the appeal. And you did ask a question about, so what's the harm? Well, the harm is if we go through these hearings and the assessor is allowed to present a case and the assessor convinces anybody that their case is meritorious, then my client will have to spend $2.2 million in taxes, which it doesn't have to spend now. So there's a lot riding on this. This isn't a no harm, no foul. This is a different situation. As far as the Circle K cases are concerned, I will point out again, the person signing the appeal form didn't have the authority to do so, just like the timely submitted wrong appeal forms that were submitted here by the assessor's office. If you have no authority to be signing the form, even though you say you do, it's not a valid appeal. That's not a debatable point. That's black letter law. Imagine if somebody simply didn't sign the appeal form and sent it in. Would the government count that as being a valid appeal form? They could if they wanted to be generous, but legally they don't have to because you didn't sign the appeal form. Well, we are doing things legally, at least I think we should be, and the statute and rule combined require that you file on the right form and you fill it out correctly and you have somebody that has the authority to sign actually sign it and you submit it timely. None of those things were done. Therefore, you have an invalid appeal. Therefore, the cases should be dismissed.
Lisa Luxon for the Clark County Assessor. Just want to go back to Mr. Sousa citing the Markowitz case. So in the case, it says time and manner refers to when the performance must take place in the way in which the deadline must be met. So here, the timing was the March 2nd when the assessor's office completed, and then the way was on a state board form. So it is substantial compliance with that. It is in compliance with that. And then to clarify in the assessor's brief that the DA, when it says as articulated above, the petitioner retrieved and fully completed the provided forms from the SOB website. Additionally, petitioner timely submitted them prior to the March 10th. That's written in the plural because there's 8 cases here. So that's what that's referenced. It's not to reference that the subsequent forms were completed after the date. It's that all 8 of these cases were submitted on March 2nd. So that's the clarification on that. As far as the Circle K cases, those cases were not timely submitted. It wasn't a representation issue or who signed the form issue. It was that they were received after the deadline. And here, the deadline is what is statutory. The statutory deadline is March 10th. And the assessor's office completed the form on March 2nd, and it was submitted. Now, granted, incorrectly, which we all acknowledge, and I think to State Board Gray's point, people make mistakes, and a mistake was made here by the assessor's office, but it shouldn't preclude the fact for the county to be able to have this case heard on its merits. Courts have found that cases should be heard on their merits when jurisdiction has been invoked. And here, the time frame, the county complied with the deadline on March 2nd. So just in closing, I would just say that while the county did comply with the time and manner, it complied by March 2nd, and it complied in the manner to submit the appeal to the state. And so the form and content, that is directory, and I think to what the Attorney General's office has put on the record too, the forms contain similar information. And so that substantial compliance is sufficient to avoid any harsh or unfair or absurd consequences that could have happened when an error is made in a form.
So I go back to Mr. Sousa's argument, which is, I think, 36 or 361.701, subsection 2, where it says the petition must be on the form prescribed by the state board, not a form, the form. And I'm wondering how you reconcile that the appeal was the document that was filed on a timely basis clearly was a form provided by the state board, but it wasn't the form prescribed for the party who's filing it.
Lisa Logston for the record. I think you look to the law on what that means. And so because it is the manner in which you're supposed to engage the State Board of Equalization, so it was a manner of the form, the form was a manner in which you're to engage them, and the county substantially complied with that. And so therefore, they met the time and manner requirements. And so the fact that there was an error in that, the courts have found that's not jurisdictional. The courts have found that that it's directory, that the state board puts these forms out, but errors happen, and maybe a taxpayer or the county picks the wrong form to submit, but it isn't intended to be a time bar, because you've complied with the time and you had the intent to invoke an appeal. So therefore, the courts have found that is substantial compliance.
Thank you. Unless there's any objection from the board, I'd like to close this hearing for deliberation. Do I have any objections to that course of action?
No, sir.
Tyree? Al?
No objection.
Tyree?
Sorry, I keep trying to unmute my audio. No objections here, Mr. Chair.
Okay, so I'm going to close this, and I will, again, this is not my normal schedule, but I'm going to take the first comment. Because of the magnitude of the issue, I see that this case will probably run one of about 4 paths. We accept jurisdiction. Ultimately, we hear the case on its merit. Mr. Souza is successful in persuading us that the county board's actions were correct. It is possible that the county then appeals to the district court for whatever reason they might. Conversely, we accept jurisdiction, the county prevails. These issues, among some of the substantive issues, would prompt Mr. Souza potentially to pursue the case to a higher court. We deny jurisdiction. The county then appeals to the district court because they ostensibly have been aggrieved by what they believe to be the false act, the incorrect action of our board by denying jurisdiction and the county board by finding in favor of the petitioner. We deny and so maybe that's only 6 courses. Good or bad, good or bad, good or bad. I am of the opinion that if we don't hear this now, we'll hear it later. It'll, in some way or fashion, it'll come back to us. I don't know whether that is persuasive in any way, but that's my feeling. I think that we're going to hear this issue, whether we hear it today or hear it next year or on remand. That's my comment at this moment. Does anybody else have any comment or deliberation? Al or Tyree?
I'll jump in. I'm kind of struggling with 2 key things that stick with me. One, it is a sophisticated taxpayer, and that's just undeniable. Should have been a much better effort put into the process. However, the argument I'm struggling with the other direction is there was no harm. Mr. Sousa did describe harm in his way, but had the original file, the original form, the original filing with the correct form being used, we would be in no different place. I just don't see that the form, creates harm. If the right form had been used, we'd be hearing these cases anyway. And I think our duty is to assess the taxability of the assets and focus in on that. So I think I'm inclined to accept jurisdiction now.
Thank you, Al. Tyree?
Oh, Mr. Chair, Terry Gray for the record. I tend to agree with what has been stated and definitely understand the arguments that have been placed and put forward by MGM. I think if I were in their position, I would make very similar arguments as well. Where I, in the past, have been a person who says, if you are derelict in the process, and you don't participate in the process, then you can't come to the state board seeking help. And I think that that's what we kind of talked about in the Circle K, where there was no action. They didn't participate at the state level. They didn't take any time to find out what was going on, and now run to the state and saying, hey, help us. On the same part with the petitioner earlier, who had called the county and tried to get the form, but never was successful, and then came to us and said, hey, look, I made some efforts. Will you guys help me? Because maybe I could have tried harder. Maybe I could have called a third or fourth or fifth time, or whatever the case it may be. But I at least can show you that I was participating and I made some efforts. And we said, okay, where we see a party making efforts, we will take jurisdiction. Though a very poor effort, the county made an effort to give us notice as the board that there was a dispute that would need us to weigh in and resolve. And then that notice was also given to MGM in a timely manner with the proper form filled out, though the date on that form after the date in which it should have been, and still errors throughout that. Again, the county, will definitely address, and this is on a public record, so the hand spanking, if you will, of the county is very well noted. They did at least participate, and so that is where I'm held up. We tried to do what is we are tasked to do what is legal, and we tried to also do what is fair. And I believe that in this circumstance, what is fair is to have the opportunity to hear the case. And again, I understand, to Mr. Souza's point, hey, look, we are now in jeopardy where we believe that we would not have been in jeopardy. But to Al's point, had whomever filled out the form pulled down the right form, and again, I don't want to go and put anybody's name on the record. We'll just say had the county filled out the proper form, the jeopardy that MGM finds itself in is no different than is not unique based upon us accepting jurisdiction today. And so I would tend to lean toward us accepting jurisdiction.
Tim, any closing comments?
Well, one comment I just want to make, and that when Tyree's talking about let's do what's fair, I think what's fair is what's good for the government and good for the county and good for the state is good for the taxpayers. And if the taxpayer had made all these mistakes and didn't file it on the right form, didn't file it correctly, I've been told now that the county assessor, Clark County assessor, has much more lenient standards to adhere to, I'm glad to hear that. But what I think is what's fair for the government's fair for the taxpayer, and they should be following the rules of the road. They used the wrong form. The statute does say the form. It doesn't say a form. It says the form. And then the form was filed after the deadline, which I find incredible. And then the form also contained a substantial number of errors. And for those reasons, I wouldn't support a motion to accept jurisdiction in this case.
Mr. Chair, if you will just entertain just a little more debate between Tim and I. What I would ask Tim is, in the case of Mr. Verselli, in that case, Mr. Verselli didn't even participate at the county level. So no petition, no form, no hearing, no nothing out at the county level. And because we had deemed that he had made efforts to participate, we decided to accept jurisdiction to give him the opportunity to participate. Is that you? And so there, where you have somebody who didn't even do anything at the county level, we said, hey, you can come to us for relief and for assistance, because we believe your testimony on record is that you made honest attempts and were blocked from participation. In the Circle K case, you have, hey, we filed this, but then we were completely silent. We didn't participate in the hearing. We didn't call and check and see what happened in the hearing. We just went completely radio silence, and then we were shocked and acted surprised when we received notice that it didn't go our way, even though they employ law firms and consultants and different things that could have helped out along the way. And so where you are silent in the process, we have said that you can't seek it. In this case, the county has not been silent. The county participated in the process and they lost. Then they pulled down a form, and they pulled down the wrong form, and they did a sloppy job filling out that form. It came to our office, and our office said, hey, you filled out the wrong form. We've got you. We note this is the date in which you have actually filed your appeal. And they took the documents, they accepted it and said, but this is the file, this is the one that you must actually fill out. So the county turns around hurriedly, and again, in error, and again, I mean, we can continue to chastise the county, but they filed the form. And the concept and the idea behind, again, the form being filed is a petition for appeal. It is to let us know that you are going to appeal. That is the only purpose that form serves, is to provide notice to the State Board of Equalization and to all parties involved that an appeal is going to take place. That is the purpose of it. It isn't the area where we have the merits of the case being discussed, or the arguments that may flow from one party to the other party. It does not in any way impact someone's ability to defend, to know what is being claimed against them or anything. It is merely to provide notice. And we were notified, even if on the wrong form and not the form used, right? Because when we read through that statute, it says, I mean, a person, including the county, I think without limitation, or including the counter assessor, is entitled to appeal a final judgment of a county board pursuant to the state, right? And it goes on, must file a petition requesting the state board to hear his or her appeal, right? So that's what, and I'm kind of reciting that a little bit from memory, but that's what NAC 361.701 says. Must file a petition requesting the state board to hear his or her case. When you go on to 2, it then talks about it must be on the form and da-da-da-da. But it is letting you know that the initial hurdle is you must file something to let us know that you plan on appeal. And they filed something, the wrong something, it's sloppy something, but they did file something, and that within our process and our history, and I will say on my history and sitting on this, when somebody has filed something, a taxpayer or the county, we have tended to go, we accept the fact, we accept the notice. Now let's get to the meat and the merits of the case, because we were at least given notice that you had a grievance, and we're here to actually be able to address that grievance. So that would be what I would want to make sure is on the record as we potentially take a vote here.
So at this point, I think the views of the board have been adequately discussed. Does somebody want to make a motion? I suspect that there's two people and that the motions would be in opposition to one another, but I think we can accomplish the same thing with one motion. Would somebody like to offer it?
Mr. Chairman, based on the board members' comments and the testimony, I move that we accept jurisdiction in the cases 117, 118, 20, 135, 136, 137, 138, 139. I think I've got them all.
117, 118, 120, 135, 137, 138, 139, 136. Is that
Yes.
the, okay. Do I have a second?
Mr. Chair, Tyree Gray for the record, I would second that motion.
All in favor signified by saying aye. Aye.
Aye.
Aye.
All opposed signified by saying nay.
Nay.
Motion carries 3-1. Tim Morris is the dissenting vote. It is now 3:30. We have been informed by the Legislative Council Bureau that we need to vacate this room by 4:30 this afternoon. Where are we?
Mr. Chairman, at this point, I would think that the merits of the case would be discussed. The merits are somewhat lengthy, given the money involved. I don't think we're going to get done by 4:30, so we'd have to split midway through, unless you want to just end now and come back tomorrow.
Well, we do have the option, Sam, would it be appropriate to hold this in abeyance and begin first thing in the morning and hear the other two cases in this section?
Sam Taylor for the record, from the AG's office. Yeah, you could temporarily table this particular case, given the nature of it, and I think Mr. Sousa is correct. I think you're not gonna make it today. So you could hear something maybe short today and then take up the merits of this particular case tomorrow morning when we return. So that is something you can do. You just need to have a motion to table this case until tomorrow.
Well, Mr. Chairman, according to our rules here, we got 15 minutes, and then 5 minutes. That's
Subject to
35
questions.
minutes. Subject to questions. So that's 35 minutes, and we got an hour.
Tim, you are an eternal optimist if you believe that we can address this in.
Well, Mr.
We couldn't
Sousa's-
order coffee in an hour.
Mr. Sousa brought all these people here.
All these people are happy to stay the night and come back tomorrow morning and hit this fresh, as opposed to hitting you at the end of a very long day.
Chairman Schiffmacher?
Yes, ma'am.
As far as the Clark County's perspective is, we do have some other cases that might be shorter, and we're willing to agree to come back tomorrow so that you have enough time to hear the cases fully.
Would that be 134, 140, and 142?
Yeah, you might not get through all of them, but maybe you could just call them. I think there's a residential and 2 vacant land, but, you could, I think you'd get at least through possibly 1 or 2 of them.
Let's move on. Let's get rid of Sousa and move on to some other hearings then. Let's go.
Well,
Do you need a motion to table this till tomorrow morning? I so move.
yes. So Tim Morris moved that we table this series of cases until the morning. I would like everybody here promptly at 9, as is set forth in the agenda. And
We need a second.
can I get a second from somebody?
Second.
Yes, Mr. Chair, I'll second that motion, and I'll even be there in person because I'm going to drop off and go hop on a flight. So
Super.
you'll have my full attention tomorrow and presence. So.
That's excellent. I have a motion and a second. All in favor signify by saying aye.
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 So, gentlemen, we will see you tomorrow. Thank you so much for your patience. Kelly, if you would call the next case.
Chairman Schiffmacher, I'm sorry, could we take a quick
Yes, ma'am.
5-minute break for the court reporter's hands?
Yes.
Thank you.
Recording stopped.
Okay, this is Bob Schiffmacher. It is 3:45. We have 45 minutes remaining in today.
Recording in progress.
I'm reconvening the State Board of Equalization on October 5th. We have tabled the cases 117 through 139 for tomorrow morning. Kelly, if you would call 140.
Yes, Chairman. Thank you, Chairman. Case 23-140, SDI LLC, Representative Barbara Henry. Notice of hearing was on page 40.
Thank you. Before we go any further, I want everybody to be aware that Tyree Gray has stepped off the Zoom, so we still have a quorum. The members that remain are myself, Tim Morris, and Al Plank, who's still attending by Zoom. If the assessor's office would introduce the property, and I understand that we have a stipulation.
Yes, sir. Thank you, Mr. Chairman. Scott Anderley for the Clark County Assessor's Office for case number 140. This is parcel number 177-33-601-012. It's a vacant 2.2 acre parcel in an R&P area. You do have a signed stipulation from the appellant and myself that was just received late yesterday. The other page in there is just an aerial showing why we are making the wash adjustment that we're making, which is basically 6% off of the valuation. The stipulation was to go from 550 down to 517, taking that adjustment into account, and we do recommend that value.
Mr. Chairman, I make a motion we accept the stipulation as presented by the assessor's office.
Do we need any input from the taxpayer if he's available?
I do not believe she's available. I talked to her yesterday, or emailed back and forth, stating that we were accepting that since she signed it and would be presenting it here to the board.
Very good. Do I have a second on Tim's motion?
Second.
I have a motion and a second to accept the stipulation. All in favor signify by saying aye. Aye.
Aye.
Any opposed? Hearing none, motion carries. Is there another case that we can call?
Thank you.
You're still.
Apologize for that. Chairman, case number 23-134, Thomas Hunn Living Trust. Taxpayer has new evidence. Notice of hearing is on page 46, and Thomas Hunn is on voice or the telephone system. Zoom. Thank you.
Okay.
Good afternoon.
Good afternoon. The first step in the process would be for the assessor to identify the property briefly, and then you'll have 15 minutes to present your case, and then the assessor will have 15 minutes, will deliberate and render a judgment. So at this point, if the assessor would, first item of business is there's new information presented by the assessors or by the taxpayer, which appears to be several photographs and a map showing distance to adjoining properties. Does the assessor have any objection to allowing this new information to be part of the record?
No, sir.
Do I have a motion to accept?
I make a motion we accept the new evidence.
Do I have a second?
I guess I've got to ask this question to remain kind of to remain consistent. Is there any reason this information wasn't available at the county?
Mr. Hahn?
At the time, at the county hearing board, Mr. Chairman Dugan make a statement that the distance from the housing look to my backyard, they need to use binocular. I know that incorrect, but I do not have information to challenge Mr. Chairman Dugan. So I went back and looked information at 372 yards, and you don't need a binocular to see a person in my backyard from those gate of the house. And also I didn't have all the pictures because the short time frame I had to go to the hearing. So I don't have enough information to develop a picture that I can send it in. I only say two reasons is the view, it should be removed, and the number of panel or solar panel on the house is not correct. It's 14 panel instead of 21. And I say that because the house is being built, the mountain view should not be correct because people can look at my backyard and my privacy.
So
not been, yes.
one moment, please. We're only, at this stage in the hearing, only questioning whether this information is appropriate to include as new information in the hearing package. It sounds to me as though this information was provided in response to a direct question from the county board. Is that correct?
Yes, yes.
Al, does that answer your question?
Yeah, and I guess I'm also swayed by the fact that the county doesn't have any objection. So I'll second the motion.
All in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. So this evidence is part of the official record. If you would orient us to the property, please.
Yes, thank you, board members. Case 134, the subject is a 2,159 square foot.
Can you please state your name for the record?
Well, I apologize. Dallas Tripp with the Clark County Assessor's Office. The subject is a 2,159 square foot, one-story, built in 2004 and situated on a 0.2 acre elevated lot with backyard views of mountain, city, and open space. Amenities include a 3-car garage, generally located in a gated community at Eastern and Sunridge Heights Parkway in Henderson, and the assessor recommends holding taxable value at $464,944. Thank you.
Mr. Hahn, this is your opportunity to present your case, which is an appeal from the county board decision.
The assessment make a value, some view, adjustment code AR01 at the value 30,000, and that was done at the time based on the construction at the time the mountain is built, and no housing there. Since 2019, the county allowed older housing, not just one or two houses, a whole bunch of houses. And those people at high elevation can look down my backyard, so my privacy has not been damaged. I also that my view no longer mountain, so I think that the sum view adjustment should be removed from the assessment.
Very good. Board, do you have questions for Mr. Hahn at this point?
No, let's move on to the assessor.
Al, any?
Not at this point, thank you.
Okay, go ahead.
Dallas Tripp with the Clark County Assessor. Market analysis can be found on page 20. The comparable sales were selected based on similar characteristics and location, Included as sales comps are 3 model match comparables with similar views backing the open space. All sales are in the subject neighborhood. Comp 7 was an active listing at the time of the County Board of Equalization and has since sold on June of 23 for $710,000. The recommendation is to hold value based on the evidence. The rebuttal regarding the view is revealed by examining the sales comps. Although there is a single-family development on a once undeveloped mountain behind the subject, the observed distance is over 1,000 feet. For the sake of argument, all comps backing the open
Objection. That's incorrect. The distance is 372 yards.
The observed distance is over 1,000 feet. For the sake of argument, all comps backing the open space mention mountain and/or city views in the MLS public remarks, and the sales clearly indicate there is an additional lot value regarding the subject's view and location within the subdivision. The comp sheet study of a median sale price per square foot of sales without pools backing the open space is $329 a square foot versus $293 a square foot for interior parcels not backing the open space, but with similar attributes, suggesting a $60,000 view premium. A further study based on current paired sales indicate the market value of the location view adjustment for the subject may be over $50 a square foot, and well supports the $30,000 view adjustment assigned by the assessor for the tax year appealed. The petitioner has given the assessor no evidence to support his opinion that the elevated location view backing the open space has no additional value. And the petitioner also appears to have constructed a rear elevated flagstone patio after the date of purchase to enjoy and maximize those views. See page 5 of the petitioner's new evidence. The number of solar panels on the subject were reduced from 21 to 14 on February 13, 2023, directly after the County Board of Equalization hearing. Furthermore, the assessor stated at the County Board of Equalization that solar panels are exempt and contribute no additional taxable value to the subject. Thank you.
Mr. Chair, Jamie Jacobs for the Clark County Assessor's Department. Just a couple of quick observations on the new evidence from the taxpayer. If you look on page 3 of his information, you can kind of see the perspective from that camera angle looking at those homes on the hill there. Of course, you can still see quite a bit of the mountain around them. And then if you scroll down to the page 4 of 5, I assume this is kind of like up on the hill looking down. You can definitely see the perspective that is either a zoomed in photo or a moved closer to the home. Thank you.
Jamie or is it Doug?
Dallas.
Dallas. In terms of land or in terms of the sale prices of the comparable properties that you listed, I see no consistency regarding, I think 1 and 2 are similarly situated to the subject with views of the open space. To the subject, the rest of them are internal, but I see no demonstrable difference between the overall prices, whether they have a city view or not. Is that consistent with your observation or at Mountain View?
My observation from looking at the sales are sales 1 and 2 back the open space, and the median sale price per square foot on those two is $329 a square foot. Those are model matches. The sales 3 and 4 are the two that do not back the open space, have no pools, and the median on those two is $293 a square foot. So that's about a 10% difference, and the only thing I can conclude is because they back the two 1 and 2 back the open space. Comps 5 and 6 do not back the open space but have pools. So their sale price per square foot is a little higher. So if you wanted to break it down for that way, that would be how I would look at it. This really wasn't a discussion at the county board. It did come up at the county board, but the issue of him having a property that was $30,000 more in land value than everybody else in the community is something that wasn't. It was dealt with at the hearing, not before.
So at this point, if we were to look at the assessment records for all of these properties that front the open space along the, I guess it would be the top of Dogwood Ranch Road, those would all have an open space adjacent adjustment?
That is correct. If you want to view on page 21, you will see an equity grid that, well, in this particular equity grid, it is simply all the model matches that back the open space to his property have the same adjustment on the land value, and they are highlighted in red, and that value being $186,000. Those that do not back the open space is $158,500, and that's under a column heading labeled land on the right-hand side.
Mr. Chair, in addition, again, Jamie Jacobs for the record. So obviously this grid here that Mr. Tripp is referring to shows that we are equitable in that neighborhood for the ones that are backing with the additional adjustment for the open space, and also noted that the indicated value on the previous page from the market analysis of $713,000, where we have the subject on at $464,943, substantially below market value.
Thank you. Any questions for the assessor's office?
I was just trying to, this is Tim Morse, I was just trying to look up real quick on your open web. Who owns the property, that vacant desert property between the taxpayers' property and the houses that have been constructed there? You've referred to it as open space. Is that...
I want to say it's owned by the city of Henderson, but I cannot confirm that. We're in the process.
So Tim, I think your question is, are we expecting any houses to be built in there after this after the upper subdivision is completed?
Yes. Well, let's just look it up here real quick. I mean, it's... Yeah, that's it shows the city of Henderson. Yes, city of Henderson owns those properties.
So
I don't know if there's any deed restrictions on those or if the city could sell them. But I'd like to point out to the taxpayer that there's no guaranteed views on any property you buy. You look at the condos that had been built out on the strip, and then they all had terrific views. Then they built another condominium high-rise right next door to it and blocked it, and there's nothing you can do. So as long as the sales data show in this particular subdivision that there has been somewhat of a premium paid for those properties along his street, I would tend to think that the assessor's office's support of the value.
Mr. Hahn?
The value, when they build the house, the values of the view had dismissed and it should be removed. That's all I asked for, because no longer valid that the mountain view. I mean, I cannot forbid, but now because of those people don't have, they can look over my backyard. They can see, there's certain privacy I've been lost, and the county still build a house and then still increase the value of premium on that piece. And that should not be fair when they build a house.
Mr. Hahn, I'm looking at this and I'm wondering whether it's a question of how that premium is being described. In markets that I'm familiar with, there is a premium for properties that back to open space, even if they, on the other side of the open space, have homes, as compared with properties that are deep inside a subdivision where there is no physical separation from the adjoining property. So it may, while you believe your view has been impacted, calling the premium a view premium may be a disservice, that it's really a separation or an adjacency adjustment. And so, as opposed to your neighbor across the street, which has, 20 feet between he and the adjoining house, or 50 feet, whatever the depth of the backyard, your separation from the properties behind you is 1,116 feet, which is 372 yards. So that's kind of where I see the distinction. Do you have any further thoughts?
The way the assessor set the value and put in certain premium and call it mountain view, it makes it arbitrarily, and even though the number of the solar panel, the information, if it not depend, it should not be in there. And I don't know how, when you call mountain view, you build older house, and it's no longer a mountain view description. Now, they are really a deep valley because, it's not really like a flat surface for that area. It's really deep down and then going back up. So the distance, the viewing distance is like a triangle between for that piece of land. So I'm not really sure what I can do. I mean, when I look at it, the county builder how get more property tax. In the meanwhile, they did not. They changed my property bill, the coal mountain view. They checked up from $20,000 to $30,000 when the view is deteriorating, and the county the one that built it, not some private citizen or something else.
So let me ask a different question. While there's no evidence in the record, do you have an opinion as to what your property is worth today if you were to sell it?
I'm not really sure I can say that because I'm not really in the position in the market and go out because each house is different, and I honestly don't know what it would be. Maybe 500-600. Maybe, but I don't know. I mean, my main concern is the assessed value. If you assess value 21 panel, then the value will be on 21 panel. How many thousand square feet? But it's no longer valid. It should be adjusted to that. I mean, when I brought it up, the chairman Dugan said, you need binoculars to look at my backyard. That's not correct for 372 yards. Unfortunately, the the county didn't bring the transcript, the actual transcript of the hearing. I would sit there and the chairman snap at me for need a binocular to look at my backyard. Because when I say, when they build those houses, my privacy have been sufficiently damaged.
Board, any further questions for the taxpayer?
No, sir.
No, sir.
Al?
No.
Okay, thank you. I'm going to close the hearing for deliberations. I have no further questions as well. Tim, any comments?
No, I just make a motion. Okay, go ahead, Al.
Go ahead, Al.
I was just going to say, I think your description, Bob, earlier of kind of open space mountain view is more around the proximity, not that you're going to have pristine mountain views forever. I think at some point, if that starts to get populated and there's more housing than there is open space, then there's probably an argument. But at this point, from the photos, it looks like there's more open space than houses. That's all I'd have to say. So in that regard, I guess I would move that we maintain the assessor's value at, I believe it's $464,943 taxable value.
I second.
All in favor signify by saying aye.
Aye.
Aye. Any opposed? Hearing none, motion carries. Mr. Hahn, I appreciate your participation in the process. I'm sorry that the case did not fall in your favor. I do wish you the best of luck in the future. Thank you. So the next case that we would normally call is 23-142. Mr. Morris has indicated that he needs to abstain, and so with that abstention, we would not have a quorum. I would like to inquire, I don't know whether the Washoe County Assessor's Office is here or is available. There was one case that we asked for additional information. That was 23-171. If the Washoe County Assessor's Office is available, I'd entertain a brief discussion as to how that case might be concluded. We can't do anything anyway. Lacking any information from the Assessor's Office. Yeah. Let's see if we can get that taken care of. I don't know whether LandCap is available. I'd be interested to know whether they had reached an agreement or not.
Chairman Schiffmacher, this is Shannon Scott with the Washoe County Assessor's Office for the record. Can
Hi,
you hear me?
Shannon. I can.
Hi,
Thank you.
I'm not sure if Mr. Polikalis is on the call today, so I don't know it would be appropriate to continue without him.
Well, let me ask a very simple question. Was that Mr. Polikalis? Apparently not. Let me ask a very simple question.
I am, yes.
You're there.
Yeah, I've been patiently observing the proceedings.
I hope you were satisfactorily entertained.
Very much so. I want to figure out how to...
Would you be willing to take your case out of order? We've got about 19 minutes.
Yeah.
Kelly, would you call 23-171?
Case 23-171, LandCap Sparks 4, LLC. Notice of hearing is on page 219. Representative Stephen Policalis, and the board requested information in a separate document sent via email October 4th.
Thank you. I'm sorry, was it Sarah from the Washoe County Assessor's Office?
It's Shannon, and if you could just
It's
give me a
Shannon.
quick moment. I don't have my paperwork in front of me, but I'm getting it.
You've got a very limited amount of time.
Okay. Good afternoon, Chairman and members of the board. For the record, my name is Shannon Scott, Senior Appraiser with the Washoe County Assessor's Office. The subject property is a 28,940 square foot newly renovated 3-floor mixed-use building at the Sparks Marina. Give me just one quick second here. I would like to ask that the minutes from the September 28th hearing be included, as this is a continuance of that hearing. I'm not sure about the order of this, but I would like to ask that should the state board choose to further reduce these values, we would respectfully ask you to do so in the form of obsolescence, as reducing this building to a 1.5 quality class would bring this parcel out of equalization with other buildings throughout the county. I'm not sure if I have a couple of additional notes that I'd like to kind of briefly go over, if the board would allow.
This is not the time at this point. We want to hear from Mr. Policalis regarding the information that I'm hoping was shared with you regarding, I don't want to hear this whole case. I just want to hear whether there was a resolution or whether there's been progress made. Mr. Policalis?
This is Steve Policalis for the record, representing the property owner. No, I've received nothing, no communication whatsoever from the assessor's office. For stipulation as indicated you were seeking in the last hearing on this, or otherwise. It's been radio silence. I hope that answers your question.
It does, but not a I'm disappointed with the answer. Sarah, or Shannon, if you have information that you would like to share with Mr. Policalis, I would like that to be shared with him. And at this point, I'm not sure that we've got time to hear the balance of the case this afternoon, although time for this series of meetings is very limited. Mr. Policalis, if you were to get information by email immediately, would you be willing to continue to hear this case, or shouldn't we postpone it till tomorrow?
I don't know what the information is they're sending. It's hard for me to promise anything without seeing it.
I understand.
This is Christina Griffith for the record. Mr. Policalis, it is in your email, and there are two one-page documents that are in there.
Christina, I know I've seen that information, but I don't know when you sent it or what it looks like.
I received from Christina, I believe, a waiver of notice for this hearing based on lack of 10 days, which I executed and returned.
Chairman
that's
Schiff, my apologies.
Yes.
Chairman Schiffmacher, it is in the email that I sent last night. I sent you two emails, one for the casinos and one that had other information. The one that has this is from 6:00 p.m. last night, and it is the 23-171 SBE costing requested, and both documents are combined on that one for you.
So I've got new evidence.
There are 5 attachments on there for different cases, and this should be the last attachment on there.
Okay, I have found my copy of the information. Mr. Polakalis, do you have the, the heading is 2022-23 test costing for SBE 23-171.
No, I did not receive any emails to that effect.
Okay, Christina or Shannon, can you make sure that Mr. Polakalis gets that information? I'm going to adjourn this meeting now. We have consumed all the time that's available to us. So I will see everybody here at 9 o'clock tomorrow morning.
I make a motion that we adjourn the meeting and that we postpone 23-171.
Do I have a second? All in favor signify by saying aye. Aye. Motion carries. Meeting's adjourned.
Mr. Chair?
Yes, sir.
Are both these meetings noticed together? They are. So essentially what you're doing, if you don't mind me saying so, is not adjourning the meeting, you are recessing the meeting. So I think you need a new motion.
I revised my motion to say we're recessing the meeting.
Do I have a second?
Second.
All in favor? Aye.
Aye.
Thank you.
Session is recessed.
Thank you.
Thank you.